Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live. If you're watching this on Facebook, we are broadcasting from Kirk's Law Corner page. If you were watching on Twitter or YouTube, you're watching this on the Marchus. The Marchus is proud to be producing Kirk's show. Thanks for watching, and please call in to ask any questions. Please welcome Kirk Pendergrass.
Thank you. Thank you for all you do, Ted.
You're welcome, bro.
We love you over here. Is my hair all right?
It's
Makeup done all good?
It's growing in a little bit. Mascara looks fine. You're good to go.
No shine. I get rid of the shine.
Yeah.
I tried shaving most of that off.
You got most of the, yeah. You got the powder on the cheeks. Everything's good.
I'm all powdered up.
Yeah.
So Chris hasn't even joined us yet.
Interesting.
So I don't know what's going on over there. But just to kind of give people an idea, I've been really busy. Went to a political leadership class this weekend. Pretty good stuff. Some stuff in there that I didn't quite agree with, but you know, not to try and toot my own horn here, but not everybody knows the same stuff that I know. So that's kind of why I'm here. It's why I started doing this, is because people don't do the same kind of research that I do. And, you know, again, I don't know everything that's out there. There's just no way one man can know all of what, I mean, again, I've been at this for over 20 years, since 1995, doing research, reading, you know, just as a hobby, you know. But the last 6 years, I can tell you, I've hit the books pretty darn hard. So I do have a lot of stuff committed to memory. You know, we all go through certain trials in life, and that's what gives us wisdom. You know, man, hit yourself on the thumb with a hammer. You don't usually forget that, even though it happens a couple of times. You know, if you're working construction, or, you know, I'm a mechanic, I work in construction, I do remodels, I fix cars, you know, electrician, plumber. I have many skills in many different trades. I'm just kind of a guy that's an information junkie, and I guess you could say I have ADD, but I contribute that to my high IQ. It's just who I am. It's part of who I am. I'm just an information junkie, and I'll spend 3 months learning a trade, and you know, I get bored with it and I move on to the next one. You know, things like being an electrician, that kind of stuff's a little bit harder to just pick up, but you know, a lot of stuff is just common sense for me. Except for like the English language, I suck, really do. I just don't pick that stuff up very easy at all. So while I can read quite well and I can spell pretty good, I'm not very good at writing. So that's my drawback. You know, I'm really good at math, but I suck at English. So yeah, you know, there's lots of people doing research out there trying to study law, and, you know, that's what we're here for, is we're trying to educate people on law, not so much as trying to help people on an individual basis. It's pretty tough. That's the reason why I'm doing what I'm doing, is trying to help the masses as a whole. You can come back and watch the videos, you know. So I'd like to give a shout out to our sponsors on Blog Talk Radio, which is Brian Kinter Randy Davis, Cheyenne Davis, and Neil Shelton. That's Future of Our Children on Blog Talk Radio. And then, of course, Ted Fogg here. And then American Common Law Academy, Lee Arthur Rice, Tony Pellegrino, Fred Kelly Grant, Angela Peru. She does the bondsman thing. She's a Bronco bail bonds. Yeah, we're doing what we can to try and help educate people and do, just make it one day at a time for everybody else out there doing the same thing, want to say hi to the people that are on right now. Rebecca, and man, I can't even actually see who all's on. So thank you for tuning in, and I don't know what's happening with Chris, but so I just kind of want to go over some things that I learned here at the political leadership thing. Let's see here. Got my notes. How the political power process works. What was the real nature of politics, leadership, inside operations, knowing your battles, outside operations, and election season. So basically, this is all about drafting, not necessarily drafting bills itself, but supporting the draft of a bill. So getting a sponsor. So let's say you have to pick one topic basically and work on that through the whole year. And your organization, you create an organization that does specifically this particular topic. That's what your organization picks for the topic to push through to get voted on. So one of the key things here was like force them to go on the record with the roll call vote. So if you're pushing something and you got something going through, I want a roll call vote. I want to see every single one of you legislators, whatever your representative or a senator. I want to know where you stand right now. And then there's kind of a formula that comes along with that. The ones that are, like a double positive that are definitely in support of the bill, you don't really need to talk to them. They're in support of it. The single plus, they're basically the ones that are definitely interested. They're listening, they're supporting it, but haven't really confirmed their vote. Those are ones you kind of want to focus on first because you want to build your numbers. You got to get that plus 50%, 50 plus 1 votes. And then there's the zero category, the ones that you don't know which way they're voting, you don't know what their opinions are, they're neutral, whatever. Then you have a single minus and a double minus. And you can pretty much forget about the double minuses. Most of the group of the people that you want to work with or talk to is the zeros because they're all undecided. So they kind of get thrown into that category of either I don't know anything about it, that kind of stuff. So it helps to, have yourself educated on what you're pushing. I mean, that's part of your planning and, what you do as an organization itself. Get yourself educated so that the representatives, especially the one that's sponsoring your bill, will at least know what to say. And you can even go so far as writing up their own statements. Give them a speech, write it all down, bullet points. So that way when they're on the spot somewhere, they can look down and look at the bullet points and go, okay, well, this bill is about this, it's about this, this, and this. So the representative doesn't actually even have to know the whole, 100% details of what the bill is itself and what it's about. If you just give them the bullet points, they can rock that, and that gets the information out there. And then you got crazy things like, doing postcards, sending out postcards. And you can do that en masse. You can get the voter registration list. So everybody who's registered to vote, you can look through there and look for the ones that more than likely are going to support your whatever bill you're trying to pass. And you can send out a list of questions or whatever, and or even statements. I support this, or whatever it is, and whatever you're wanting to do. But you use the postcards to basically, they're already pre-addressed. All you got to do is stick a stamp on it and sign their name and send it in to the address that's already pre-printed on there. The easier you can make it, the more successful you'll be. So whatever it is you're trying to push, you want to make it as easy as possible. And when those postcards hit the representative's desk, especially the ones that are zeros, are going to, look at that and go, oh, okay, well, I guess my constituents want me to vote this way. Or if you've got one that's pushing a bill, that's sponsored a bill that's you don't agree with, same thing. You can hammer them with those same postcards saying, no, we don't support this. And if you vote this way, we're going to be voting a different way, and we're going to be voting for somebody else next election cycle. So it was called fear tactics, because they want to keep their job. And that's the thing. It's not even supposed to be a job. It's supposed to be an honorary position representing the people. But that's long been gone since I couldn't even tell you, probably clear back to 1812. It's all about getting in there and being a politician, making the money, making the taxpayers pay for their home, their boat, their car, and their jet skis, and going golfing and going to Hawaii and going on vacation. It's kind of sickening, really, but what things have turned into, instead of being an honorary position and actually representing the people. But these are some tactics that can be used. Some other ones are obviously emails, requesting to, phone calls. You can request to go in and actually talk with the representatives. Sit down and talk with them and say, look, these are reasons why I don't support your bill. Or these are reasons why I support a current bill. You get with your local representatives and you get in there and you talk to them. You want to make change. That's what we're going to have to do. These are the people that are responsible for all that kind of stuff. So sitting here on Facebook like this is really not going to do a whole lot. So, I guess what I'm doing is trying to help educate the rest of us on what we can do, because that's always the multi-million-dollar question. What do we do? Well, we need to speak up, and speak up to the right people. Get a hold of your representatives and find out. Start asking questions. Why are you voting this way? Who are you? I want to know what you support and what you don't support. And so I know who to vote for next election cycle, because if you don't support my views, you're not representing me, and I'm not going to vote for you next time. Yeah, Holly says Google all state reps. Actually, I have a whole list, which obviously is going to change here shortly. Probably, I think voting's tomorrow or something. Tuesday. Yeah, tomorrow. So, that list is going to change a little bit, but I have a complete list for all of Idaho. And, I rubbed some elbows with some of them last night. It was a good time last night. We had this is the thing out here on the West Coast, those of you on the East Coast and all on the family law stuff, you think family law is the only thing that's going on. I got news for you. Google search Bundy Ranch standoff, or just the Bundys. You'll see what's going on. We have several men that's sitting in prison, have been in prison for over almost 2 years now, that are just now getting to a trial by jury. Okay. This is the tier 2 part. The tier 3 part, where they started, they've been tried twice. The second time they finally found most of them not guilty, except for two of the individuals, and they ended up just taking a plea bargain here just not too long ago, which are still ironing that kind of stuff out. But these men have been in prison for 18 months. That's unconstitutional. It's unlawful. We know it is. So there's a lot more things going on in this country than just family law, which is, part of the stuff that I studied and have studied prior to family law. I've only been studying family law stuff for the last 3 years. So, again, There's a lot more things going on besides family law. So, when you step outside of the fact that it's not just family law, this is a it's a worldwide thing. It's called Agenda 21. Now Agenda 2030 is what they're moved on to next. So I think, Chris, is that you, brother? Nope. No, hold on. Mute that. So yeah, we got people taking up arms. We're doing stuff out here on the West Coast. They originally stood up in 2014 against BLM, which is actually Bureau of Land Management, not Black Lives Matter. So we have basically like the Forest Service. They go out there on the land, and it's supposedly federal land, which has been unlawfully seized. If you've read the Constitution, Article 1, Section 8, Clause 17, specifically says that they're not allowed to own land. The federal government is not allowed to own land unless by permission by the state, and then only for the purpose of forts, ports, magazines, and arsenals, and other needful buildings. Because what we actually delegated as a power to the federal government was to protect us in defense, okay, our land in defense from foreign invasion. That's what we instituted government for, no matter what it is. So that's why they have the power to make regulations regarding commerce. I mean, that's Article 1, Section 8. You read all of those powers that were delegated. That's the limitations. The federal government was limited to these specific topics and no further. So yeah, like Josh Tuttle says, for all you parents going through the broken family system, you're not alone. You're not. It's happening all over. But there are other things going on within our court systems and in our country that is not family law. It's outside of family law. I can tell you that right now. It's huge. And it, again, goes back to Agenda 21, with taking care of medical, controlling the money, getting into these fraudulent, unlawful contracts, your birth certificate, your social security number, your driver's license. All of those things are actually fraudulent contracts because we actually go to the common law, the Declaration of Independence. Our rights are creator endowed rights, and those are unalienable rights. You can't place a lien upon those rights. And that's what they've done. They placed liens through contracts, which are fraudulent contracts, because when you're talking about unalienable or unalienable rights, they cannot be bought, sold, traded, given away, or taken away except upon civil death. That's just the way it is, because they don't come from man. They came long before the Constitution was even thought of. They pre-exist, they're pre-antecedent to the Constitution. So, I don't know where you're at, Brother Chris, but hopefully you can make it. If not, we'll just keep on rolling.
Sorry to interrupt. I just got an update from Chris. He that case in Texas is kind of at a head sort of thing, so he's working some things out. I don't know if he has trial tomorrow or the next day, but he's going to call in as soon as he ties up a couple of loose ends, he said.
Okay.
So until then, if any of you guys want to call in with any questions at all, keep in mind Kirk is not an attorney. He's not licensed to give out legal advice. So this is for educational purposes only. I have a question for you if you want to. I should do this. Sure. All right. So my case specifically is nowhere near as bad as anybody else's. I do what I do only because I know that I am lucky to not have gone through what a lot of these people have gone through. And at this point in my personal life, me and my ex-wife are on the same page. She understands that I haven't been able to work for more than a couple of days at a time for the last 2 years, and like a lot of people do come to understand, it doesn't matter what the custodial parent wants or not. What the court, once the courts are involved, the courts are going to seek out child support in my case, no matter what, whether my ex knows I can afford it or not. So now that we are good, we are on the same page. She doesn't want to see me going into jail for the arrears that I have. There's part of the reason why I went out of business and moved. There was a lot of different factors like my hands, but one was the contempt hearings that I kept having to go to. So, and now that she'd like me to help but not go to jail, she would like to see those arrears disappear. Is there any way to do that? I should know this, but I concentrate on the crazier stuff, not on my stuff.
There is a form that your ex can fill out to forgive that debt. That's about the only way I know of forgiving the debt, and it has to come from her. The other way is, fraud. You don't have a right to a cause of action to collect this from me, and I'm going to have to ask you for your name, your job title, your oath of office, your surety bond. I know this might be a little above some people's heads here, but this is some effective stuff to shut it down. And what's your standing? What right are you claiming that I have deprived you of? And who are you? What's your standing here? You don't have any right to have a cause of action against me, as I'm not under any obligation to you, unless it's the person themselves. So a lot of this stuff, if we can do this paperwork, a lot of it can be beat right in the beginning. You don't even have to show up for court, because as soon as they receive that paperwork, they're going to start backpedaling. You start asking them for things that they're required to give you. They're going to freak out because they don't have an oath of office, most of them, and they're required by law to have one. And what I mean by law, I'm talking Article 6 Article 6, Clause 3.
Right. Yeah. The worry is, of course,
if you're an elected official or in a position of public trust, that's the only two positions we have. Period. You fall into one of those categories. Either you were elected by the people, or you were appointed as an employee, an agent of an agency, to perform specific duties. And that's what's your job title? What's your job description?
Yeah, we all know it's not.
If your job description is outside the scope and authority of the Constitution itself, the controlling law, we got a serious problem here.
We know it has nothing to do with the best interests of the child and whether the custodial parent gets the child support money, because there's billions of dollars every year in undispersed child support money that they keep for themselves on top of the incentives that they get. So they don't care whether she wants to continue child support. They want it to continue, so they get their incentives. So I'll look into that paperwork, and I'll let you know personally how that goes.
Okay. Well, hopefully that can work out with you. Do something.
I'm sure it will. So please, anybody else call in?
As long as she's willing. We do have 2 calls here, but here's the thing I wanted to kind of run down again, kind of, because this is kind of a continuation from last week. Speaking with I can't remember what the gentleman's name was, but he was touting how he had changed parental law in whatever state there statutorily. Well, that's the thing. And the question is where is the delegation of authority to make statutory law in that manner? Because there isn't, and you won't ever find it. Not in law, you won't. Okay? So there is no statutory authority to make any kind of statutory, or there's no statutory authority, period. It's to codify the law. So when we're talking about murder, okay, murder is unlawful, right? But where's the punishment for that? Well, the punishment should be found in your statutory law. Most of the time, you will find it in Title 18, because that is a universal crimes and punishment. So whether that's federal or state, it should be under Title 18. Yeah, I was reading John here, John Patton, unjust enrichments, emoluments. Yep. And that's what Chris Hallett's been working on, and it's, man, I can't wait for that for Congress to actually make a final decision and ruling on that. You know, there's another case somewhere in Utah, and that one, as soon as that one's going to set case precedents, because that's going to be basically the first one that's actually utilizing what Chris Hallett has done aside from his own case. So, I mean, that's going to seriously rock the boat, because basically and essentially what that does is every single public servant, because they're all paid by tax dollars, you act outside of the law, that's a criminal indictment, because you're being paid to do something, perform a specific moral duty and ethical obligations under the law, and you go act outside of that. That's you know, color of law. And well, you're going to prison. And that's what we need to be focusing on. Is you want to make a change, we need to get our paperwork filed. And it starts in the very beginning of, it doesn't matter what case you're in, criminal or civil. And I don't care what that first initial court says or does. We have to file our paperwork. We have to stand upon or understand what and who we are, what rights we have, where they are in law, so that we can properly claim them. And when you properly claim them, that dictates the jurisdiction. Just like 2 + 2 = 4. That's a principle behind mathematics. When you claim these rights as creator endowed rights, that dictates the proper jurisdiction. And that proper jurisdiction is the common law jurisdiction. Okay, we have constitutional law, we have civil law, we have criminal law. Okay, so if you can understand, or I should say comprehend what I'm saying here, is there's different parts of law that have different jurisdiction. And the problem is if you read Article 3, Section 2, it says suits at law. That's the common law. And then suits of equity. Okay, that's estate. Kind of like real estate, but estate. So those are the only 2 lawful jurisdictions on the land. But what they've done is, again, they've duped us with the Constitution. And if you read Article 3, Section 1, it specifically says that all judicial powers in the Supreme Court of the United States, and that the legislative branch has the power from time to time to make these other courts that are inferior courts. Okay, but Article 3, Section 2 limits what those courts are, and they're courts of law and courts of equity, period. But again, we have to understand our history. You know, in 1775, with the Declaration of Arms, the reason why we took up arms, the necessity for taking up arms. And that's you know, I read pretty much read the whole Declaration here a few episodes ago. So if you want to actually understand what the Second Amendment actually means and where it comes from in law, that's a good one to watch. Or just do a Google search for Declaration of Arms, or Declaration for the Necessity of Taking Up Arms. I call it Declaration of Arms for short. But they talk about the admiralty jurisdiction being extended onto the land again. And this is in 1775. And so in 1812, the War of 1812, when they came in here and burned our capitals, trying to rid our documents and, you know, killed our representatives in Congress, and in our states, state representatives, and they instituted their BAR people, British Accreditation Registry. That's from the British Crown. And then in 1845, this is what they did. They extended that admiralty jurisdiction back onto the land. And that's the key problem. It's not family court, it's admiralty jurisdiction, and it's affecting every single court that you go into. The first one you go into is an admiralty court, administrative court. Okay? So, you know, I went to our Idaho Supreme Court here last week, and actually was it last week or week before? Week before. And I sat in there and I noticed that the American flag didn't have any gold fringe around it. So that tells me that that's not an admiralty court. And that was Idaho Supreme Court, although that was the appellate hearing. The appeals court and the Supreme Court are all in the same, they're the same jurisdiction. Okay, it's the Supreme Court. And the same thing when you go into these federal courts. You know, they're actually still the only ones that are acting under suits of law and suits of equity per the Constitution, Article 3. So that's why I say we need to file our paperwork, make your arguments, you know, file your briefs, and it's the same process, okay? And ask anybody who has filed in federal court or filed any kind of something against somebody else as the moving party, as the plaintiff. You will automatically get a Rule 12b motion. Motion for dismissal for lack of jurisdiction, for failure to state a cause of action for which relief can be granted. Okay, those grounds are in your whatever court you're in, the rules of procedure. It's your objections and affirmative defenses. Okay, they're all listed in there. And you go through that list and you can pick out which ones that you know that you can argue. And the most common one is lack of jurisdiction, and it's personal jurisdiction. And a lot of times when you well, when I've gone in and I've seen it on plenty of videos, it's the same thing. Oh, well, we have locus jurisdiction. Well, they don't say locus jurisdiction. They just say, oh, well, this happened here, over here, and that's within our jurisdiction, so we have jurisdiction. Well, that's great, Your Honor. That's locus jurisdiction. We have 6 more elements to jurisdiction. And until we get through those 6 elements and the moving party proves that this court has all 7 elements of the jurisdiction, and then and only then can we proceed in this court. Until then, I don't consent, because we are a republic, by the public, by consent. So as long as you don't consent, nothing happens. And so even if they dismiss your motion for dismissal, you demand your finding of facts and your conclusions of law, your points of authority, because that's what they have to do. But if you don't hold them accountable and force them to perform their duties in accordance with the rules of procedure, they're not going to do it. They're not going to do it. But the thing is you get through that first court, but you make all of your arguments, you make your statements. Okay, don't act emotionally. Treat that judge with respect. It don't matter. You are making your case. You're making your arguments. And I could care less what the judge feels, thinks, or even how they rule, because all of this will go to the next court. So this is why it's important that you get all of this in and on the record. File your paperwork and make your arguments. I don't care which way the judge rules. You can almost guarantee in the first court you go into, you're not going to get justice. Okay, that's just a given. Don't give up. Don't feel discouraged. You know, in fact, it's probably better that they do that so that you actually have a right to a cause of action for denial, or actually, I'm going to say it right, deprivation of rights while acting under color of law, which invokes Title 18, Section 242. You know, and the Ninth Amendment clearly says that our rights, you know, there are other retained rights by the people, and those shall not be denied or disparaged. So when they deny your claim of your rights, or claim of usurpation of power and depriving you of your rights, a trespass upon your property, again, those are your claims. You have every right to make those claims. But when the judge acts outside of their moral duties and ethical obligations under the law, that creates a right to a cause of action immediately, right there on the spot. I don't care what happens in that case from that point on. It's all fraud. It's void for any effect. So you take your right to a cause of action and you take it to federal court as a suit at law. Title 42, you got section 1983, civil rights stuff, then 85 and 86. You know, there's other parts to the suits at law. So you want to make sure you read all of those. And this book right here is a killer book. Okay, you see how thick that thing is? Okay. This is O'Connor's Federal Rules, Civil Trials. This is everything to do with the procedure, practice in the federal courts. Okay. And this has all sorts of different stuff. I mean, it has everything you need here. All the case law that comes with it. I see it, Ted. What's happening?
Since Chris couldn't call in, I asked Ante. Is that how you pronounce his name?
Ante?
Ante. Thank you. To call in, and he says he's calling in a second. So I just wanted to give you a heads up if you'd like to talk to him on the show, Ante.
Let me see if that's him right here. Ante, is that you? You with us? 7731. Just a killer book. Okay. Yeah, I'll stick that thing in. Okay. This is
he says he's on hold. Can't listen or talk. That means he's in the waiting room.
No, he's here. I got him in here.
Okay. Ante, you're in.
Area code 385-7731, the last four.
Yes. Hello. How are you guys?
Great. Who are we speaking with?
This is Crystal.
Oh, okay. I thought I knew the number.
Right? Could have just done the last four. Like, how could you forget me? Right?
Right?
FYI.
So, how are you guys tonight?
Honestly, I'm a little drained. It's freaking cold here. It's been snowing. We aren't getting snow right here in the valley, but right down the street and up on the hill there on the mountain, we've been getting some snow, and it's been cold.
Right. We went down south this weekend, and it was gorgeous down there, but came back to the cold.
Yeah.
Which was nice.
Mom's headed out of town, too. She's going to go down south.
Right. There you go. Heading south, young man. Okay, so I love you talking about this, about, you know, the deprivation of rights. That's a very, very key subject that a lot of people have, you know, need to work on when they're working on their child cases, because they got to realize that that's, you know.
Well, again, let's get away from just child stuff, because this is in general. This is law.
It is in general.
And I'm about law. So.
Right.
Deprivation of right is a deprivation of a right, whether it's parental rights, whether it's your Second Amendment rights, whether it's your First Amendment rights. Okay,
right.
Your First Amendment rights. The First Amendment just kind of gives you a little bit of a list of what some of those rights are, and that's why the Ninth Amendment is there. And that's what disparage is about. Is don't laugh at me, don't mock me for claiming my rights that are creator and God rights. Okay, and you can't deny those rights. Period. And if you deny those rights, that's a deprivation of a right.
Right. Correct. And so it could be under anything, you know, unless you are, you know, under due process, you are found guilty by a jury of your peers.
Right. That's what's called civil death.
Right. And a lot of people don't realize that you're eligible for that. You know, and, you know, there was a discussion the other day on it as to, you know, how many states allow for what kind of jury trials. And so many people think it's better to go with like a bench trial, but it's not. You know how, you know, I don't know. It's kind of a weird situation to be in, to even think that you'd even go in front of a jury.
Right.
I guess is a good way to say it.
So if you go into court and you demand a trial by jury, and you're being denied a trial by jury, you automatically know that you're not in the right jurisdiction, because we always have the right. It's an ancient right.
Right. Now, there's a lot of states who don't have those rights, who have abolished those rights. The states have written them off, where you don't have a jury of your peers.
Well, again, that's what the federal court's there for. I demand my right to a trial by jury be preserved here, Your Honor. And if you want to deny me that right, well, we're going to federal court.
Right.
Again, file your paperwork, demand your right to a trial by jury, let them deny it. Okay, well, where's your finding of facts? Where's your conclusions of law, your points of authority in the law that says that you can do this? And they can't do it.
They can't come up with anything.
Because they've already ruled. Now, if you want to try and get allow the judge to have a get out of jail free card, you can do a motion to reconsider. So it allows the judge to go, well, maybe I ought to reconsider my ruling.
Right.
When you start exercising, and see, this is the thing, it's your right to due process of law. Okay, notice an opportunity to be heard is the short version of due process of law, aside from the law of the land. Okay, so all of this that you filed with the court, motion to reconsider, motion for the compel the judge for the finding of facts and conclusions of law. Okay, when you start exercising your right to due process, and you're putting the judge in a pickle because you're forcing them to perform their duties, all of them. But if you
will you explain the difference between a motion to reconsider and a motion to vacate and a motion to set aside?
The motion for fraud, motion to vacate for fraud, they just don't even want to hear them. And that's why if you actually look at Rule 60D Delta, not Bravo, it talks about fraud upon the court, and the court can entertain a motion to vacate for fraud at any time. Or, here's the or part, or as an independent action. Okay? So if there's been fraud committed upon you, this creates the right to a cause of action. A new right to a cause of action as an independent action. Okay, so you don't file in the same case, in the same case number. You file a brand new case, and your grounds are fraud upon the court. Period.
So how would you do that? How would you say, if you already have like a case, how would you file a whole new case to reconsider? It's
not reconsidering.
No. Okay.
Now I'm the moving party. I'm claiming deprivation of rights by fraud.
Right.
So you take the power from the court that just committed fraud upon you and allows the fraud to be perpetrated upon you and continued in allowing the order to go through or the judgment to go through against you by fraud. What you're doing is you're going to a separate court. As an
so would you say that would be like an appeals court or whatever is a step above the court you're in?
No, as an independent action, brand new action, because your right to
same court
occurred at the time that you were you were frauded, and the judge failed to protect your right.
Okay.
Free from fraud.
Okay.
So, I mean, it's a whole new case. It has nothing to do with the case that you're currently in front of the judge, whatever.
So what would happen if you get the same judge?
You will never get the same judge.
Okay.
It's a different court. It's federal court. You're going for fraud.
Oh, okay. I see. Sorry, I missed the step where you said, I thought you meant you're still in the lower court or the trial court, and then you move it up. And okay, never mind. Okay, sorry.
That's what
I missed your step.
Action means.
Right.
Independent action. It has nothing to do with the case that you're going to be, claiming that this fraud happened in. I mean, that's completely illogical to go back to the same man who allowed the fraud to rule on whether or not he allowed the order to go. He signed the order or did the judgment, knowing the fraud was there. mean, you would never go back to that same person. That's completely illogical. That's
Right. Okay.
the rule of
So you go to the next higher court or the federal court.
Well, again, independent action. It's not about going to the higher court because you're talking about appealing that decision. No, independent action. A whole separate brand new case. You
Okay.
file your claims. Okay. I claim fraud upon the court. And this is a new action. I've been deprived of my rights. And the grounds is fraud.
Okay.
And if you file in your state, it'll be under the rules of civil procedure. If you go federal, it's under the federal rules of civil procedure.
Right. Well, makes sense.
I'm trying to read what Ted's got going in here. Oh, yes, let's bring Brian on. And I don't know if Ante has called. Brian, are you with us?
I am now. I tried to call using my phone, but your phone system don't work that way.
Well, it does.
Ante is on. His number
Yes.
is hold on 1 second. Let me scroll.
3391
Yeah, yes.
216.
Wait,
216. Okay. All right, hang on there, Ante.
where is it? Let me make sure.
Oh, I tried to call in, and what happens is it says that I'm put on hold, so I can't even listen.
Yeah, that's a shitty
Yeah,
side effect.
I have
of
to
Zoom.
accept you, admit you in over here, and
Oh, wait a minute. Let me.
trying to do a few things all at the same time here. So you got anything you'd like to share, Brian?
So how'd you like those documents I sent you?
You know, honestly, I've not had a chance to look at them. I have been swamped busy all frickin' weekend. I woke up Saturday morning at 5 a.m. all gung-ho to go to this political leadership class that was, an 8-hour class. Started at 9 and then we got out of there at 5:30. And
Say hello to everyone.
what's that?
I said say hello to everyone.
Hello, everyone out there. Robert is a long-haul trucker.
And on my time off, I study.
I was just gonna say, and he's another law guru guy who reads a lot. He actually
Thanks
has
for
a
the
subscription
compliment.
to Westlaw, so he actually reads some pretty good stuff. And I go down to the law library as well and read straight out of Westlaw, or turn right around and pull the book off the shelf because I love reading it out of a book.
Well, I go to Westlaw because I don't have the luxury of going to the local library.
Well, I mean, it's pretty much a walk-in law library wherever you go with Westlaw.
That's right. I sit down in truck stops, show drivers stuff. People just
Yeah, just spread the word, spread the education. And another thing about Westlaw, when you're looking at some of that stuff, like American jurisprudence, and what I've found is, I'll save some stuff that I'm doing research on from American jurisprudence, and I'll get home, and then I'll try and find some of the cases that it gives reference to, and I can't find them online at all. I can't find them on Justia. I can't find them on law.cornell.edu. I can't find them on Google Scholar. So, those are some pretty compelling things to go, okay, maybe I really need to go look at these cases, because if they're not being, put out there for the general public, they're probably pretty powerful cases. And, considering the source of where these cases are being quoted from, we're talking about American jurisprudence, which is constitutional law section, volume 16, which there's actually 3 volumes, A, B, and C. There's quite a bit of constitutional law. And American jurisprudence, I mean, there's, again, I can't even remember how many volumes are there, but there's like 80, I think there's like 80, between 60 and 80 volumes of American jurisprudence, which, in Latin, that's the conscience of the law. So, the internal dictates of, the science behind law. So there is some science in law. All right, well, let's wrong mouse. I've got two different laptops going. Ante. Ante, you're with us.
That's the right phone number.
3391.
Correct.
All right. I can hear a voice.
There you are. How you doing, brother?
I'm doing well. I'm doing well. What's yourself?
Hanging in there. Had a pretty fun, eventful weekend, full of stuff.
I had one of those myself too, so some entertaining things.
Yeah,
but
I'm sure mine was a little different kind of entertainment, but
yeah, mine was involving knocking at midnight and people hollering my name, talking about they want me to come with them, and I just sat in my place smiling like I ain't going nowhere.
Where's your warrant?
Huh?
I said, where's your warrant?
Oh, it's over here in the Cleveland area, but you know, it is what it is. So
right.
that's what brought on federal litigation, just proving our point. You know, so now it's like now you're sitting back and you're just like, okay, a few more hours and you're home free. So something that should have never happened, something that should have been cleared up before, but you know, they want to mess around with the error of their process.
Yeah.
So
well, that's the kind of stuff.
It's over a speeding ticket. So there.
Right, but this is kind of the stuff that we faced with, you know, people who are active in claiming and defending their rights and being active in the courts. There's some retaliation that comes with that. I mean, we need more and more people doing this same thing.
Yeah, and you know, the retaliation is a guaranteed thing to happen. You'll be retaliated against civilly, criminally, any which way they can. They're going to come at you, and you know, they do that because, well, just like any other bully would. You know, bullies are bullies because
that's where I was just going to go. It's just like the schoolyard bully. You know, you try to stand up to him man to man, you might get your butt kicked. But next day you come back with two of your buddies and confront that bully and have a nice little talk with him. You know, hey, stop. And it's going to stop right now because I'm claiming deprivation of rights. And so are these other two people over here. You know, and I'm not talking about using force or violence. I'm talking about, you know, the correlation here, the analogy I'm trying to give is standing up to the bully is getting more than one person to stand up to the bully and claim the same rights violations or deprivations of rights. You know, that builds your case, along with having court watchers, you know, people who witness the events that happen during your specific hearing, and you document all that stuff. You write it down on a piece of paper.
Oh yeah, document.
Claim, the judge denied it. Mr. Perrick made this claim. The judge denied it. You know, all of that's documented so that just in case, I mean, you're now the witness. You're a witness to these crimes because they're crimes. Okay, Title 18, crimes and punishments. You now have the ability to write an affidavit on behalf of the person you court watched for. When they go to federal court, because now they have a right to a cause of action, your affidavit gets to go in there. And then when they try to pull the transcripts and that lower court trying to cover their butt, don't put those specific things in their court transcripts. Now you have somebody with support who witnessed actually what did happen while you were in court during your hearing and the crimes that were committed during the hearing.
Well, there's also the fact, like even with my domestic relations case, they refused to let court watchers in. They refused to let people watch the case. Adamantly refused. The bailiff actually said if they tried to come in, since they're not party to the case, that, you know, she was like, I will get the deputies up here. We'll be placing people under arrest. Okay. You know, and this is something that regularly occurs in Lake County Domestic Relations Court. And, you know, it regularly occurs, you know, to fathers. It happens to
when
fathers.
you're dealing with that kind of stuff, wherever the corruption starts, okay, the deprivation of a right, okay, if I was going down as a court watcher and I had a bailiff tell me, well, you can't go in there to that public hearing. Oh, really? What's your name? Do you have your oath of office on file? Do you have your surety bond on file? I'd like that information right here, right now, please. And by the way, do you have a business card? So I have your name, your address, your official job title. And then you send them a lawful notification letter. Say, who are you? You know, where's your oath of office? I demand all these things from you because you have deprived me of a right to go into a public hearing. So
yeah, but you know, that's all fine.
Chip away. These are the remedies that we have to chip away at this stuff, one little thing at a time. And it, you know, we can't just sit back and go, oh, well, they won't let us in there and not do anything.
Well, that's what I've been doing. Is having. I've always, every time I've came up there to file something, I bring someone with me. Every time I came up there to, you know, to a hearing or whatever, I brought multitudes of people with me. You know, I would always do this, and these people got to witness this stuff, but they would never let them in the courtroom. But they've been documenting and all this stuff. They've been putting down the dates, the times, etc. And then they send me an email to remind me and themselves for in the future, when the time does come, of everything that transpired. And, you know, that's just how it is. It's document, document, document. And, you know, when you've got a judge who's sitting on the bench that says, I don't have to listen to the Constitution, I don't have to listen to federal law, there's only one law I have to listen to, and that's the law that's in my court, and the only people I have to listen to are my three bosses on the appellate court, no one else. You know, when a judge takes this kind of a hostile, aggressive stance against you, when the judge permits motions, you know, done in secret hearings, aka ex parte, motions that accuse you of causing a violent scene at a school. So on paper, it looks like you're this vicious monster, but the court fails to recognize at the same time that the time you were accused of causing this violent scene, you were in front of that judge's magistrate, getting a protection order to protect your children.
Okay, so this is the reason why I say that you need to make your statements, you file your paperwork, you make your statements in court and on the record, okay? We're not, again, going back to what I already covered, more than likely, we're not going to get the justice we seek when we go into these first courts. But when they deprive you of these rights and they start acting under color of law, that creates a right to a cause of action in an independent court as a separate claim. Claim, not complaints. I don't deal in complaints. I deal in claims.
Yep.
So this is the key. You can sit here and whine and cry about what they're doing and how it's unlawful. You know this. You know it's corrupt and blah 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 blah. Stop whining about it.
And just do it.
And go to and file a new case.
And just keep on filing.
Right, but you go into it's a whole separate case, a brand new case. You're claiming deprivation of rights, acting under color of law, and you let the new judge or judges, depending on how far you go, decide whether or not that judge or that prosecutor or that public defender even acted with ineffective assistance of counsel, or even if you're a hired attorney, or whether it's, you know, the other side, the plaintiff, if you're talking about family law stuff. So, you know, you let the new court decide whether there was an usurpation of power, if there was a trespass upon your property and a deprivation of rights.
Now here's a question.
Right to due process of law.
Now here's a question for the court watchers that were denied. Could they join into it?
Yeah, with an affidavit.
Excellent.
That's what I'm trying to tell you. It doesn't matter what happens. If they get denied to go into the courtroom, that's an affidavit of truth. That's a denial of a right to go in and watch a public hearing. Okay. Oh, well, here we go. Mr. Hallett. I was actually going to let Crystal have a little say here, see what she says. She had anything to add to that. Crystal, did you have anything? Come on.
You know what? I have to play this. I have to play the fifth because I took another call and I put you guys on hold.
That's not pleading the fifth. You're just what you're.
Sorry.
Yeah.
Hi, Crystal.
Hey, on tape. So, well, whatever. So I do apologize for, taking another call. But I have to admit, it is very hard. And it is very, you guys make it sound pretty easy to do this transition. And it absolutely is not as easy as you guys think it is. I mean, to make the transition from a lower court to the federal court is a big transition. And it takes a lot of patience, understanding, knowledge,
research.
A ton of research, a ton of, knowing your case so in and out, up and down, left and right.
Okay.
And before you even get to the point where you even file a federal, you need to do a timeline. You need a timeline and you need interested parties.
Right. So how long did it take you to study before you filed your first federal?
Do I have to be honest or can I lie? I would say, okay.
This ain't domestic relations court, so be honest.
Right. Okay. Sure. And I don't have to declare my income either. I would say when I started talking to you, so Kurt, how far did you and I go back?
February.
Okay. So February is when I started. I mean, I had already kind of looked up information anyway before we started in February, before you and I started talking. And so between working a 60-hour work week as a nurse and doing all this, I probably would say hour-wise, probably, oh my God, I don't know. So about a year-ish, off and on, 4 or 5 hours a night for the last year.
Okay, there you go, folks. Crystal really
mine goes a little
federal stuff until
mine goes a little bit deeper because I even go back because mine involves every single element. The family court, civil.
Okay, so Crystal actually came on to my show in February through Randall Stone when Randall Stone and I were together doing Blog Talk Radio, and that's when she kind of started doing the studying for the federal lawsuit stuff. So some of us get it better than others. I personally haven't had the time to read my book here, the O'Connor's Federal Rules of Procedure and Practice. I need to dig into that. So it just takes some time. So it depends on how serious you really are about wanting to go federal, because that's the proper court, proper jurisdiction to deal with civil rights violations. Your state courts can, but if you're going to be complaining about what's going on in a state court, my suggestion is the federal. Go federal. All right.
And yeah, I have to agree with that. Like for me personally, since I had such an extensive history with all three types of courts, family court, civil, and a criminal, my research had to extend much further. I mean, before I even started talking federal, I was already 3 years into research. And, it's real critical to get the proper mindset for federal court too, because it's completely different than a state court. So, when people reach out to me and ask me for help, I tell them to watch federal cases like Hardwick versus Greeking on YouTube. It's a completely different style of court. And, that's just, you got to know what your case is, know how you were wrong, which right were you deprived. And you got to be able to put that using eloquent words in a lawful fashion that the court comprehends. And, that's where such, resource tools such as Black's Law Dictionary, like the O'Connors, which, by the way, Kirk, I took your advice. I ordered me one.
What do you think of that book?
Yeah, I did. That's why I read a lot of law journals too. Sometimes you'll find the wording in law journals.
Right.
And
the nice thing about the O'Connors is it gives you the case law that's currently recognized in the Supreme Court, in the federal courts. They already know what these cases are. So when you follow the rules of procedure and practice these rules of procedure, everything is already there. And you use what's in the book. Because when it does come in front of the judge goes, oh yeah, I'm aware of that case. I'm familiar with that case. And your case just moves right along. Of course, I'm just speculating because, I haven't been there yet. But given the way the books are and understanding what this book is doing, when you utilize the information that basically this is actually the stuff that's coming from the federal courts, from the Supreme Court of the United States is saying, we recognize this stuff. We're well read on this stuff. We already know what this case says and what the merits of the case are. So when you file your paperwork, they already know. Oh, well, you're quoting this case. Yep, I know that one. Again, I know that one. I know that one. Okay, so it makes your case go a lot easier when you have current cases that are within the knowledge of the judges that have already set case precedents. And it's right in O'Connor's book. Okay, it was like $20. I don't know.
Okay, so for those of you who can't afford it, there is such a thing as Google Scholar that is free on the internet. So for people who can't afford or don't have time to read, Google Scholar is an amazing way to find case law that goes with what's going on.
And let me reiterate on the Google Scholar. Another thing that I personally do myself is after I find something on Google Scholar, I go to the local college, which, for me over here in Cleveland is Cleveland Marshall School of Law. And oftentimes when you walk into the library and you ask somebody for help using LexisNexis, you'll have a free access to LexisNexis in that law library of the local community college or the local, 4-year or 6-year, whatever it is, college. So they'll allow you to use the resources. You'll have to pay for the pages printed out. But I strongly recommend backing it up with the LexisNexis research on your case and find out the true holding. And if it's applicable, by all means, cite it. Because in the end, they're just looking for a way to utilize confidence trickery to deprive you of your proper standing in the proper forum.
Right.
So I find that is oftentimes the easiest way to destroy a prosecution is challenge the standing, challenge the forum.
Well, that's what jurisdiction is. Jurisdiction is standing. Jurisdiction is forum. That's the thing people don't quite understand about jurisdiction. That's what I'm talking about. There are 7 elements to jurisdiction. Those are 2 of them. Okay? Personal jurisdiction, that's 3rd. Due process of law, that's 4th. Substantive due process of law, that's 5. Okay? It's all jurisdiction, whether you want to say it's the forum, whether you want to say it's whatever, it's all about jurisdiction, because you have to understand what jurisdiction really is, and it's control over you. Do you understand this jurisdiction? Meaning,
and that's also another wording that they use. That's actually a legal term, understand, which means you're standing under their authority. What we got to understand is we, the people, we overstand them, but they like to trick us to thinking otherwise.
Well, we don't consent to any unlawful jurisdictions that don't apply to us. And the moving party has to establish jurisdiction, not the judge. The moving party does. And you'll find that out when you start taking actions on, and you become the plaintiff, the moving party. Okay, you're going to find out real quick what it's about, jurisdiction, because you're going to get that Rule 12b slammed against you, and you're going to have to know how to answer that. You're going to have to be able to articulate every single jurisdiction that they claim you don't have.
And it's actually, to the novice, it's going to be completely confusing. But, to others, though, they'll be able to establish the grounds. And that's another thing that, I appreciate about the federal court. versus, as far as my experience goes, Lake County Domestic Relations Court. The federal court says, hey, we got to construe what he's saying liberally. We got to take his filings and pleadings and look at it very liberally, giving him a lot of playroom because, he's not coming in representing himself as to the perfection of lawyer standards. So we gotta take that into consideration. And, if you could just understand the basics, the fundamentals, most lawyers realize most people don't have a clue what the fundamentals are.
Right.
And they actually train lawyers to destroy people who don't have a clue on the fundamentals. So,
yeah. And they'll use legalese, legal terms to trip you up, and it works. But see, once you learn this stuff, and that's the part I talk about, making your statements. You just make your statements. You know what you know. You make your claims and you make your statements, and you leave it at that. If the other side tries to bring something up that you don't quite comprehend, leave it alone.
Now, I'll say this. What he was saying about most people don't understand how did he put it? They don't understand the basics. Okay. The problem is most people that study this stuff, they don't even know. Even attorneys don't even know the basics. If you are not taking the time to learn the principles of law, you don't even know the basics. The principles of law are your maxims of law. Your principles never change.
Mm-hmm. Amen.
Your methods do change.
+2 = 4.
Yeah, your methods are your procedures. Procedures are always changing. But the principles of law, if you don't have your different maxims of law down pat based on the subject matter, that's where you're going to find your problem is at.
Okay. Well, let me interject a few little things that you guys are saying, because I don't want people to be so scared that they won't file a federal case. Mm-hmm. If they can go through and read Smith versus the United States of America, I'm pretty sure it's Smith. It's a whole entire thing about being a pro se or a pro per litigant as a plaintiff. And it is a very good read if you're looking to go pro se, about how the court doesn't hold you to a higher standard, to know the principles, to know the maxims, to know all that. So, I don't want people to hear this show and think, oh my gosh, if I don't spend a year or 2 years understanding this, I'm never going to get through a federal. Most judges and most magistrates in a federal court are very understanding as long as you are trying.
Right.
Mm-hmm.
And they give you a whole lot of leniency in what you're doing. Now, you have to remember, the case in Utah is a 20-year-old boy who filed a lawsuit here in Utah. And that being said, he doesn't know it all, but the court is giving him the latitude and the leniency to learn as it goes. And that's one thing that I don't want people on the show to be so overwhelmed thinking, oh my gosh, if I don't go to the law library, but I have a suit that's an amazing suit. Look at the chick in Indiana. I mean, 20-year-old girl in Indiana who filed a lawsuit against her father for depriving the rights of her, her mom. Handwritten. It wasn't even typed. It was handwritten. So be careful we need to be careful with what we say to people so that they don't get so overwhelmed or blasted thinking, oh my gosh, I'm never going to be able to do this. Right. You can do this.
Right.
I completely agree. And that's why I say the federal court is a completely different environment, because people are used to either criminal courts or civil courts or family courts where they just get raked over the coals. The whole mentality of the federal court is completely different. It will blow your mind away. You just got to you got to put the work in, people. And, please don't be discouraged. Federal court will be easy compared to the rest of them.
Hey, I'll tell you this. one of the best YouTube channels out there, and I'm sorry, I am by no means a liberal or a conservative. I'm a political atheist. I don't believe in either party. But the Ninth Circuit gets a lot of slack because everybody says they're this big liberal court. They have a freaking YouTube channel where you can watch their cases daily. Yep. And I'm going to tell you what, I've seen them hand attorneys their rear ends.
Oh, yes.
Right. Look at Harvard versus Brechen. They handed them their asses on a platter. Yes. And to a point where...
Okay, hold on.
The court...
Hold on. The thing we need to understand here is you don't even really have to know, what law they have violated. Basically, what you have to do, and this is just the bare bones here, you have to know what your rights are and claim that they were deprived. And then it's like telling the story. Every time that I talk to somebody on the phone, that's the same thing. The story you're trying to tell me is the story that the judge wants to hear. The judge doesn't want to hear, well, Officer Joe Schmuckatelli over here deprived me of my right, acted under color of law, and that's a violation of Title 18, Section 242. No, what the judge wants to hear is, I don't really know a whole lot about the law here, Your Honor, but I'll tell you what, Joe Schmuckatelli over here pulled me over, demanded my driver's license, registration, proof of insurance. I asked what crime did I commit. He couldn't articulate what crime that I committed, so I refused to give him my identification, my registration, and my proof of insurance, and he smashed my window in, drug me out of the car, beat the crap out of me, and took me to jail. That's all the judge wants to hear.
Okay, but I beg to differ with you on that. If you are going federal, you do need the code to go with it. The federal code or the civil rights code, whatever it is, to go with it.
That's for your
correct.
Okay, that's for your claims of protection of your right. It's actually up to the jury to decide who violated what crimes.
Mm-hmm.
Okay, that is correct, but you do need the code.
Always check the jury box.
Okay, so Title 42, Section 1983 is what you're actually talking about. We're not talking about Title 18, Section 242. We're talking about 1983.
Correct.
Okay, that's for your claims, your right to a cause of action.
Now, but you do know, under Title 42, Section 1983, when it talks about a 14th Amendment citizen, you do know to stay away from the Bill of Rights, don't you?
Oh, yeah.
As in, you don't have access to the Bill of Rights under the 14th Amendment.
Yeah, that's why I love the 9th Amendment.
Well, the U.S. Go ahead.
Okay. When you are filling out let's say if you use the court form for a 42-1983, for example, which is a very easy way to go. You walk in, you can get one of their forms, or you can download it online, and it's available in every state, USA. You can fill out a 1983. You do need to know what civil rights codes goes along with what you are alleging.
Right.
Yeah.
Yes.
You do need to know that. So you don't just walk in and tell a story. You say under like a 18, 16, 12, 21, or, perjury or whatever. So you say, okay, this is my right that was violated, and this is what happened.
Right.
So you do tell a story to a point, but if you don't know enough research that you can't tell them what code was violated, then they're not even going to look at you.
Yeah, they won't be interested, and they'll grant a 12B motion to kick yours. And, no,
they won't even take it.
Right.
A lot of times,
what is the name of that case?
Yeah. So I think Chris is on. You got anything to add in here, Chris?
Yeah. As a matter of fact, I was just sitting here listening to you guys talk. By the way, hello everybody. What's happening?
Thanks for joining us.
I haven't talked to you in so long, Chris. How are you?
I know, right? It's been all about, what, 2 hours?
Right. Hey, I got off work early and I still was late calling in.
Is it because of her rabbits?
You know what? That rabbit is a deep hole. And let me tell you, because of my dog, my rabbits ran out of dog. My rabbits ran out of rabbit food because of my dog.
Your rabbits ran out of cat dog food?
Yeah, that thing. Yeah. That's
y'all keep talking about a 12B6.
A what?
Hold on. Let's let Chris have a word in here.
Okay.
Well, go ahead, Chris. I was I was listening, and the one gentleman was absolutely correct about how to apply and know and understand how to practice law based on the maxims of law, right?
Yep.
So when you take and use the negative nexus, for example, that I created just as a for example, because it's easy to explain. That's based on a maxim of law. 2 negatives equal a positive. So because I was able to take that and break that down, it was kind of good and kind of bad for me, because it showed the court that yes, I do understand the articles of practice probably better than lawyers do, which unfortunately now is bad for me, because now I have to be, when I go back to do my case, they want everything high and tight, and I do mean high and tight. So,
yeah, but Chris,
which is what I'm working on now. So that's it's a good and a bad
really
thing. Yes, it was good. It was good to argue on behalf of my clients, but for myself, it was open mouth and walk in. So, hey, it is what it is. But when you're talking about your maxims of law, one of those is also law is the science of what is good and just. Okay, so when you can break it down into scientific methods, well, it's not just trial and error. You have to theorize, you have to plan it out, you have to experiment with it and test it, right? That's the process. Mm-hmm. So you apply, when you're practicing, you're basically doing what scientists do, following the scientific method, right?
Yes.
You theorize it, you create, you work the numbers out, you create your theory, you create your test conditions, and you test it repetitively. And when you can create the conditions that you get the same result over and over and over again, then you can say, hey, under these conditions, these certain things, when applied together, you're going to get this end result. Okay? Yeah. And that's what the court tries to do, is to be able to say, okay, all things being equal, if, A leads to B leads to C, are we going to get to, for example, emoluments violations? That's kind of my favorite. And the answer is yes, at least by the application of my method of practice, which is loss prevention. So because this process, this methodology, this form of practice is not something the court's ever seen before, but you'd be surprised how often every one of us does it every day and don't even realize we're doing it in our normal everyday jobs.
Right.
It could be anything from the guy working the hamburger stand, and he follows a process from the start of that, making that hamburger to the end. It's the same process over and over and over again.
Right.
So this is no different. This is stuff you people do all day, every day. You just don't even realize you're doing it. So, that's what you need to break down and examine, is what process do I follow to get from point A to point B, and then point B to point C, and so on. And then just apply that methodology to when you actually pick up the book, the Black's Law book, for example, and you start reading through it.
Yep.
Okay, and you can say, well, let's see here. John Jones presented this piece of evidence in court, and there's no way he could have gotten that legally, because for him to get that violated my my HIPAA privacy rights, right? So John Jones picks up this piece of evidence and presents it against you, but he obtained it illegally. Well, if you read the Black's Law book, that's poison fruit, or fruit of the poisonous tree.
Yep.
That means,
doctrine.
Right. That means that piece of evidence and everything around it is now poison fruit or tainted and needs to be stricken from the record.
Yep.
Right. That's the methodology in criminal court. These are the things that you need to understand, and these are the things you need to study. So when these guys are telling you, watch these videos, they're not kidding, because these videos teach you how to apply these different doctrines and these different maxims of law, and where they fit and how they fit and why they fit. So,
well, this is why I tell people I'm posting links right now to law.cornell.edu. I do a lot of my research and work out of there when I'm, not going to the law library.
As do I.
Justia, and I have
as do we all.
Looked at a little bit
right.
Google Scholar, but I tell you right now, I like law.cornell.edu a lot better than all three of them, because it has so much stuff. Where you click under Get Law, you've got the Constitution. You have all the rules of procedure, depending on what rules of procedure you want. You have the CFR. We have world law. And then here's the kicker. Annotated Constitution. Okay, the annotated Constitution has been written over time. And some of the precedents, the case law that's in there, actually refers to things like the Magna Carta. And so that's answering Nicholas's question in here that I just saw. Well, what do we do about da-da-da-da-da? Okay, well, the Magna Carta, talking about in forma pauperis, okay, the Magna Carta originally in Chapter 40, which in the 1225 reissue in Chapter 29, says we will sell to no man, we will not deny nor defer rights or justice. Okay, that is in full force and effect today. That was already interpreted by Lord Coke way back in the day, and it is in our annotated Constitution. Okay, it also references things like the Federalist Papers. Imagine that. Okay, the makers of the contract define the contract. Okay, that's where we get into the argument of the Constitution is not a living document. It's a contract, legal binding contract pursuant to contract law. So which means here's another jurisdiction, okay? Contract law, separate jurisdiction. It's not criminal law, it's not civil law, it's not common law, it's contract law, okay? We have to understand that. I mean, if you're really wanting to be effective and really rip them a new one, simple concepts of contracts. It must be presented in complete writing at the time of signing, okay?
I'll have to call back in a little bit. My phone's getting low.
All right, thank you, Brian, for coming on.
Like another thing that's helped me greatly with the concept of law in general is, like how Chris was talking about, he got this formula for the nexus, the negative nexus. For me, personally, because, I just get math, I just understand it. It's like a second language to me. I speak 5. If you want to count math, 6. But,
how you do that.
For me, the federal court, it's kind of like proving your case in federal court, and even in any court, really, is kind of like how you come up with a math proof. You have to test it over and over and over again. And if you get the same results, using different formulas, but you're getting the same result, it's no longer a theory, it's a proof. It's a given. And, again, going back to like things such as fundamentals of maxims of law, these are things that are absolutely given in the law. Things that, like, hey, there's no disputing it. If this happened, it's If this happened, it's go ahead. And, by doing it, keeping it simple, because there's a lot of people that get lost in the legal.
And, you know, you just got to do proper study. You got to, it's one thing to study for hours and hours, but you know what? If you don't know how to study, you know, those hours are spent in vain.
You know, it's funny that the last couple times that Chris and I have gotten on the phone together, it's like, what are you doing? Oh, I'm sitting here reading legal maxims, or I'm sitting here reading out.
Fortune cookie hour, as we call it.
Yeah,
you know, seriously,
that's a lot of mine and Chris's conversation. What are you doing? Oh, I'm reading what Kirk sent me. Oh, I'm reading. I found out that's pretty interesting. I found it. You know, it's one of those things where, believe me, I know every injustice that there is to incur from everything. And, you know, I don't say that in a bragging mode or a badge of honor. Quite frankly, I wish I would have never learned. But,
man, there's days I feel that way.
Yeah, but at the same time, because it's forced upon me, you know, it's kind of like, hey, I went out for the football team. Hey, I got a starting position. Guess what I got to do? I got to go hit the gym after I finish my books in school and pull good grades. Now I got to go hit the gym and go work out so I can stay on the football team. And, you know, it's really one of the processes that, you know, a lot of people feel overwhelmed. They feel too busy in life. And you know what? I'll say it like this. I'm a contractor. You know, I'm an electrician. I'm a plumber. I'm a general contractor. And, you know, I work with my hands. I work with my back. You know, I've had a broken neck, 6 thoracics, you know, that were herniated. I know what it's like to be in absolute excruciating pain. And you know what? I do have a life too. And you've got to balance it out. And I think the biggest help is from reaching out to other people. Sometimes Crystal, sometimes Chris, even you, Kirk, you know, and other people that have gone through this trauma. The first thing that I find when people deal with these family court issues is that they have such a trauma. You know, to this day, I'm still traumatized. You know, I mean, but, you know, the first thing is to get a clear head and a clear body. You know, you got to function. You got to be able to have a clear thought. And there are days, even to this day, where I struggle so immensely with that. So it's not unnormal for you people out there listening to the show for you to be completely dazed and confused. You know, and
I do want our listeners to understand, especially those of you that are in the family law stuff. You know, in 1985, I was the child that was taken by CPS and ripped from my family and put into foster care and group homes, and I ran away and lived on the streets. And finally, after I caused enough problems with them, they finally gave me back to my mom at 14 years old. But, you know, I understand, I comprehend, I feel, I have empathy for you. I know the trauma that you're going through, okay? I may not know exactly firsthand about having your kids taken from you, because I still get to see my 3-year-old right now. But I also have 2 older daughters that I was never allowed to see because mommy just took off. One's 21 and one's 20, and the 21-year-old actually just made me a grandpa here about 2 years ago. So,
congratulations!
I want you folks.
Congratulations, Papa. Welcome to the club.
Right.
Congratulations,
Dad.
Kirk.
Well, I got at least 20 years, or at least I better have 20 years before I.
Well, I just want our listeners to understand and comprehend and know that, you know, all of us probably on here feel pretty much the same way. We know that what you're going through is horrible. You've been traumatized. We know that you're going to act emotionally and you're going to have an emotional response. You know what? That's pretty freaking normal. You know, when you've been traumatized, you don't act normal. And come on, what in this day and age, can anybody actually define what normal is? I mean,
you know what? Somebody once told me what normal is. They said, normal is what everybody else is and you are not. And I said, what is normal? And he repeated the answer. And I said, I'm going to ask you again, what the hell is normal? He goes, so what are you trying to say? I said, how do you know what everybody else is? He just was like, wait a minute, what? So,
and that again goes to perception. And
normal is what we are, and they are not.
Yeah. Well, no, normal is what everybody else is, and you are not. That means that, in other words, everybody.
No, I just flipped it on you. Sorry.
Yeah. Yeah.
Well, I don't know. Let's see. Black's Law.
I got to be careful what I teach you because you flip that shit around on me too much.
Hey,
yeah, ask Andre about that.
Right?
Hey, young Jedi, listen here.
The force is strong with this one, isn't it?
Listen, every time I talk with Crystal, I keep on thinking of that scene in Meatballs. He shot my hair. He shot my hair.
Okay, hold on here. I found normal in the my 6th edition Black's Law Dictionary.
Well, then it wouldn't be us.
According to constituting or not deviating from an established norm, rule, or principle, conform to a type, standard, or regular form, performing the proper functions, regular, average, natural, Railroad Commission versus Kanawha Operating Company, Texas Civil, blah, blah, blah. So I guess it's actually been defined normal as the norm. So I guess all of us that are making our claims are actually acting outside of what's normal because they're all running on complaints. And they're following their own practice and procedures that's not in accordance with the law.
It's funny you say that. As when you were bringing, I looked that up and I ran across the word norm, and I'm thinking the thing that came to my mind was a visual of me sitting at the end of the bar, and cheers, Norm.
That's what I was just going to say. Norm's the guy at the bar asking for the next beer.
That's right. And it's like, okay, is Norm the guy at the end of the bar? Because the court seems to think Norm is the guy at the other end of the law table. It doesn't know anything else other than that.
No, right? Normal is the person who thinks you're crazy because they have to hire a psych evaluator to call you crazy.
More
that's how they try to win your case.
Yeah, more pseudoscience, my favorite.
Right.
Yeah. I call that SMU. Shit made up.
Well, let's see if we can maybe talk to somebody out there in Facebook land or Twitter or whatever. Give us a call at that number here, 1-408-638-0968, and then you'll have to enter 376-657-800 to join in here so I can see you. Come on here and ask
crazy group
questions.
Now, can I mention one thing when you guys are talking about research and study? And this is how I kind of started mine. Okay, yeah, this is probably not normal, but okay, here we go. So when I was trying to...
Ain't nothing about us.
Right. So when I was doing the research, and you got to be abnormal to do all the research that we probably have, that we've all done, is I just started typing in keywords. Like you take it like a document and you type in and you see a word and you're like, okay, I don't know what that means. Like you were talking about, like
ancillary.
Yeah, that one, or minute entry, or some weird one.
STP trust.
Yeah,
what?
You know what? And that's why
STP trust.
I can't hear you, Kirk. Which one?
SETI Key Trust.
What is that?
Yeah.
Yeah. See.
Read that one.
But I don't even know what you just said. Could you spell that?
Well, phonetically, it's SETPEEKEE trust. Now, in Latin, it's CESTUEQUETRUST.
Okay, Mr. Latin expert, Mr. Hallett, what does that mean?
I'm still trying to make out what he says. It's like he's breaking up.
Yeah, I can only hear like I got the C part.
Are you saying C like Charlie or S like Sierra?
S like Sierra.
Well, sounding it out, it's with an S, but it actually starts with a C.
Okay.
That's definitely one to look up, folks.
Is that shit in the brain? Well, okay. So so what I was telling everybody in like a normal tone is if you don't understand, like if they're talking about that you lied in court or there's fraud upon the court or, they're saying that you did something, look it up and, just start typing it into the Cornell Law, type it in to Google. It'll probably take you to Cornell Law and it'll give you the codes you need for your case.
Yes.
Very simple, very easy way to do it. And that's how you start. So you start with, like, let's say perjury, because that's a big one in all our cases, right? So you start with the word perjury or a lie. And then you go from there. And then that goes to the one thing, and then that goes to something else. And then you think, oh, well, shit, what else is there? Right?
Good
and it
question.
leads to yeah. Exactly.
And here's the answer. When you talk about the difference between perjury and fraud, even though, one is a lie by omission or one is a lie by commission, the difference is you're standing in court. In other words, are you a party to the case or are you an officer of the court? Now, if you're an officer of the court and you commit perjury, that's the fraud upon the court, right? By an officer of the court. If you're a party, okay, you technically can't commit fraud upon the court because you're not an officer of the court. But you just perjured yourself. So yes, it is the 16. What is it? 18 subsection USC subsection 1621. I think is perjury, right? So
2381. Or wait, no, that's treason. Pardon me.
Yeah, no, isn't it 16?
Treason, perjury. Anyway. It's all the same ballpark.
Yeah. So it's 2384 for perjury.
So anyway, you take the perjury element of it and you can apply it to a party, right? But you can't apply the fraud upon the court basically, which is criminal frauds, 18 subsection 1001, 1031, 1038 in the criminal context. You can apply to the officers of the court because they are officers of the court and they know better, right? Because they're supposed to be held to that higher standard of practice. Remember we were talking about that? So because they're held to that higher standard of practice, you can apply that criminal fraud to an actor who's an officer of the court.
Because ignorance of the law is no excuse.
Right. Basically, the exact same methodology we use in loss prevention to fire a store manager who committed some crime against the company, whatever it would be. And those are policies which are basically the exact same thing as statutes. So, which, again, parallels. So stuff you do every day without realizing it.
Right.
So, you follow the company policy, that's the same thing as a legal statute. Well, okay, let's examine that for a minute because not all of those apply. And here's an example of one that cannot apply. I got a letter from one of the competitors, as I call them, whining and crying about my practice being an unauthorized practice of law. Well, wait a minute. I've got a letter from the Florida Congress and the Florida State Commission for Department of Corporations and Department of State that has authorized my practice. Okay, and I've got all the numbers and all that fancy paperwork. And so basically what I told this other actor is you don't have jurisdiction to apply that statute. And they went, oh, shit, he's right.
Right.
And they had to drop it. So
yeah, and
that's basically the thing.
It's real important. That's why it's real important. Even though there's been so many times in my own family court case where I just wanted to straight out tell blatant lie, And because all these lies are being said about me. And that's why, again, it goes all the way back to the beginning, back to a moral code. Me, I'm a Christian by faith, but, and I'm the chief of all sinners, but, at the same time, there's a moral code that comes along. So if something doesn't sound right for you novice people out there, if something's like, wait a minute, that's a lie, you can't say that. Chances are you're 100% right.
Right.
And you know what? It's a moral thing, but it's also a maxim. You just got to find out what it is.
The maxim you're talking about is law is the science of what is good and just. You just described that maxim of law that I've already applied.
Right.
Yeah.
So I'm going to take a quick break here.
Where, I think for the novice, for the first timer, for the person
just put him on hold, Kirk.
All right, hold on here, guys. We're going to take a break. I really have to go to the bathroom.
TMI, rabbit friend.
Body functions here. Sometimes duty calls.
Amen, brother.
5-gallon bucket and Gatorade bottles for.
Guys are disgusting.
I can make another.
Oh God, we are sick.
Make sure you get the Wi-Fi.
I'm a construction guy, so you got to work with what we got in the field.
Okay, we'll be back in a short break here.
All right.
There, help I take the mute off. We back yet?
I think so.
Ah, okay. Well, wait for Kirk. Maybe he went out to have a smoke or something. Well, I don't know.
Is there anybody out there?
Yeah, let's just wait a
Not if
second.
you can hear me.
We'll go.
Come on.
Is there
Okay, so-
anyone
All right, don't make me mute, guys.
Anyway, before we go completely off track,
Hold on. Let me play this real quick, Chris.
One of the things that he turned the music back on. Never mind.
Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Alright, guys. Yeah, I just want to give him a break since he's on camera the whole time. He doesn't get a chance to. There you are. He doesn't get a chance to have a break. So, welcome back, Kirk. Welcome back, everybody. Kirk's Law Corner Live, guys.
Where did Ante go?
I don't know.
He must have dropped out.
Maybe he needed a break too.
Yeah, so
His phone may have died.
I noticed that I've been going back through on my phone some comments there by Brian Van Aken, and kind of back to what I was talking about, the trust part there. Let me bring. Oh, this is Brian. Brian, come back. Bringing Brian back on. Yeah, the SETI-Q trust. Okay, your birth certificate. I know this might be going off track, so I just want to say this and get this out of the way, and then we'll go back. But your birth certificate, you know, they call it a certificate of live birth, and what they do with that is they take it out to the sea, and it's a death certificate. You're lost at sea, and they take control under that contract as the agent for the principal. So that's part of the fraud that is brought upon the people when you sign a certificate of live birth. But again, we go back to contract law, which originated with the Roman civil law clear back in the 6th century. That's fraud. You can't enter into a contract unknowingly, unwillfully by fraud. When that nurse at the frickin' hospital hands you this affidavit, because that's what it is, it's an affidavit that the mother and the father are supposed to fill out, and then Vital Statistics takes your name, converts you to the language of the dead in all capital letters, and you know, that's dog Latin. They take control as the agent for the principal. They trade that out on the stock market. And that's why they're pushing for you to get a social security number right away as soon as the child is born now, so they can start getting that Title 4D funding, Title 4E. But it's all a fraud. And if you know the argument like I do, is it's like, produce the contract so I may scrutinize the contract in its entirety. Oh, well, we can't really produce the contract because, well, that contract has been destroyed. Been sent to sea. Well, wait a minute. Where's the written part of the contract? Because any contract has to be in writing, and the contract is the controlling law. So if you can't produce the contract, first of all, if you can't produce the written contract, which stipulates the terms and conditions of the contract and that jurisdiction that it falls under, there is no jurisdiction, and it's fraud. That's my argument.
So how do we apply that? Just following the methodology and the scientific process, how do we apply that? Where does that leave us?
Pursuant to the statutes of fraud.
Okay, but
so this is what I go back to: is anytime I look at a case, I look for the first instances of fraud. As soon as you find the first instance of fraud, that's your grounds. That's your right to a cause of action.
Right, or counteraction, depending on the circumstance.
Counterclaim.
But
counterclaim.
Yeah.
Yep.
And the reason I was asking that was because going back to the contract, the contract is in, terms and conditions defined in the preamble to establish justice and ensure domestic tranquility.
Right.
So where does that play a role in establishing justice and ensuring domestic tranquility?
That's
if you're going to declare that fraud, that means there's no authority to establish justice and ensure domestic tranquility. It's another never-ending circle of circles.
No.
That's what we're trying to break.
No. You got that backwards, Chris. There's no lawful authority to create that contract, and when you're dealing with creator-endowed rights, unalienable rights, that contract is void from its inception. Marbury versus Madison, 5 U.S. 137.
All right, which goes back to again. Well, let me do this a different way. Johnny grows up, graduates high school, goes to work, starts saving for his or her retirement, and wants to walk into ABC Bank and open up a retirement account for whatever that might be, an IRA, whatever. And if that contract is void, what happens to the money that Johnny is going to put into that IRA if there's no way to enforce that contract that says Johnny is entitled to that money? See, this is what I'm saying, the never-ending circle of circles. So when I say choose your battles, that's the kind of thing I'm talking about. So, I'm not disputing that saying that you're wrong, because you're not wrong. What I'm saying is scale it down, make it something manageable, right? Don't make a mountain out of a molehill. And if you keep it at a molehill, well, the court can work with a molehill, can't work with a mountain.
Right.
So, and that's one of the best. That's one of the things that will define your success or failure in court. Is if you walk in with this big mountain of crap, they're going to look at you and go, "Dude, there ain't no way in hell I can deal with that."
Well, yeah, my argument was super simple right there.
Right. But if you walk in, but it goes back to, there's got to be a method of enforcement somewhere. And if that contract is void, where does the enforcement come in? I just use the IRA as an example. Right? So there's got to be a starting point somewhere. There's got to be a place where we can agree to disagree and go a direction, pick one and go. And that's the problem right there, is there is no common ground anymore. Nobody can even agree to disagree anymore. So there's the, where do we start?
Well,
and the answer is there's no answer.
Where do we start? See, this all goes back to the common law and bringing everything under common law. You only consent to the common law jurisdiction, and which is what I tried to get through on the last show last week, was your affidavit of status.
Right.
That declares who you are, what jurisdiction you consent to, and when you make your Rule 12B motion, motion for dismissal for lack of jurisdiction, It's the personal jurisdiction.
Right.
So, and until the moving party can prove that, well, they say, well, if they were to say, well, we have this birth certificate here. So whatever the contract that they try to present, saying, well, you're bound by this contract. Okay, now my argument is that a fraudulent contract? I demand to see the contract in its entirety so that I may scrutinize it.
Right.
And they're not going to produce
because when you're born, when you're born, you can't enter into a contract under contract law. You can't enter into a contract with a minor.
Yeah, but your parents are the one that do this.
Right. Exactly. So when you grow up and you want to challenge that, you entered me into a contract, and I wasn't capable of refusing a first right of refusal. It's an interesting argument. I mean, I could see where a judge would be sitting there scratching their head going, yeah, this makes total sense.
This is why it goes back to the affidavit of status, because what part of the affidavit of status is I'm over 21, which is called sui juris. Right. I'm perfectly capable of handling my own personal matters here. And like what you said, I didn't sign that contract. That contract right there on its face is null and void, because now I'm of lawful age.
You're going to laugh when I tell you this, Kirk. Somebody from the state of Florida must have been listening to the show last week, because I got in the mail on Thursday, Florida certificate of status. Oh, God, I shit you not. For E-Clause, it came in the mail. I hadn't even requested it yet.
I followed Kurt's advice on that because, like you said, Chris, it brings up an interesting argument. Because another thing is, another argument that could be presented playing devil's advocate is, well, we never knew this was a living, breathing person. Look, it's on paper right here. They've never identified themselves. So I just figure, you know what, regardless if it's going to work for my personal case or not, it's definitely an argument to be brought forth. Like, listen, now you guys know I'm a living, breathing human being. Before you didn't, but now you do. You're not.
Yeah, you've been put on notice.
Right. So for this to issue a challenge, then obviously you're challenging standing, jurisdiction, forum, et cetera, et cetera, et cetera, when we're discussing this, correct?
Right. Again, back to the 7 elements of jurisdiction. Standing is one of those elements.
Mm-hmm.
Yeah. And then another thing that, I found was pretty advantageous is when I did enter it in, the court called me up right away. It's like, hey, what do you mean? What are you saying with this? What are you following? Listen, just file it. That's all you got to do.
Yes.
I hit him with the motion to challenge the standing after I gave a notice of entry appearance with the tax affidavit, which is the affidavit of status. And, I followed the instructions. I filled out the affidavit. I used the template that was given, and I put my information in my state, my county. And then I sent it off to the Secretary of State and the Attorney General. And I made sure to mention that in the filing, it was CC to them, So that was a thing where maybe they weren't expecting that, and that's probably where some retaliation came back at me at, because they're like, wait a minute, this guy figured something out, and but it can't hurt. The way I see it is, I'm letting them know, now they've been put on notice. You're dealing with a living human being, not some entity. And I'm telling you, I'm challenging your standing for you to come at me, because
personally.
in the end, I am one of we the people. And just as much as they like to argue, hey, your 11th Amendment rights, well, we the people are the first branch of government.
Yep.
And we are the most powerful branch of government. And since we are of that class, who is a lower part to question us? That's I'm not going to say that's what you're going to sit here and argue in court, but I'm just going to sit here and say, that's the concept behind the argument. Excuse me, you're not even a real person. Who are you to bring any kind of accusation against me? You know, you're an entity.
That's the part of where, when we're doing, like Brian just said, mention the special appearance. And I was actually going to pull this up just to even show you what I'm talking about. This is in my own rules of procedure. I'm going to pull this up here. But go on, let me get this pulled up. Rules of procedure right here. And it's in here. How you appear. It's a notice of appearance. Idaho Rules of Family Law Procedure, IRFLP.
I mean, Kirk was trying to help me find it in Ohio. They didn't have it there.
Well, it's gonna be there. You just have to dig for it. And it's
Ohio makes nothing easy on you. Trust me.
It may not be in your family law, because sometimes the family law will say, well, the rules of civil procedure apply as well as these rules. So they're actually just using the civil rules of procedure, and they're adding on these other rules of procedure. You got to remember, this is all supposed to be civil when you're in civil court. So the
which brings up a very interesting point.
That is actually the controlling rules of procedure.
Right. And when it comes to who decides what rules we're going to follow, you know, Article 1, Article 3, equity, blah, 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 and you request clarification in open court, which rules are we following here? And they say, okay, we're going to follow Article 3 rules. And then all of a sudden, ABC lawyer from Dewey, Cheatham and Howe says, well, I'm going to apply under the Ohio Revised Code statute, blah, blah, blah. Wait a minute. Under Article 3 proceedings, statutes don't apply here. So, you know, your argument is moot. And
so you're saying you're admitting that this court doesn't have jurisdiction?
Exactly my point. That's exactly where I was going.
Okay.
So what you're trying to say is they're trying, well, yes, it does. Yes, it does. Well, if the court grants you the ability to insert statutes that don't apply, that's an emolument.
Yep.
And an emolument, remember, is defined as any advantage, profit, or gain received as a result of one's employment or holding of office. And because, their employment as and holding of office as a officer of the court, they're attempting to gain an advantage over you to apply a piece of quote unquote statute or whatever that cannot exist in that forum of proceeding, being an Article 3 proceeding. So,
and for the
in other words, they don't have the element of standing, which is the element of jurisdiction, to bring that argument against you, right?
And for the novice out there, this is why you have to pick so many different brains. Because, like me personally, I've applied both of these things that both of these men are talking about. You know, the affidavit status, I challenge standing, and this is often an instruction when, you know, that I take from other people. This is why we reach out. This is why we network, you know, with other people to grab bits and parts. Because, you know, not everybody's argument is the same. No, I mean, everybody's argument is different. So when people say, hey, can you create a template so everybody can use? The answer is no. You know,
well, what can't be done.
This particular part is. Okay, this particular part is. Because this is your affidavit that you file with this notice of appearance. So now I'm going to read right here, Idaho Rules of Family Law Procedure, Rule 206, general or special appearance, okay? A, general appearance, the voluntary appearance of a party or service of any pleading by the party, except as provided in Section B hereof, constitutes voluntary submission to the personal jurisdiction to the court. Now B, motion or special appearance to contest personal jurisdiction. You have to do this. If you want to contest personal jurisdiction, you have to do this motion right here, okay? A motion under Rule 502 2, 4, and 5, whether raised before or after judgment. Okay, I'm just going to stop right there, and I'm going to go to this Rule 502, same rules of procedure here. Rule 502.
Go ahead to that real quick. Let me iterate something. People, when you're hearing these rules and stuff like that, every state has different rules, but they're generally the same. So a good way when you're putting together your motion, you put together the header, whatever court you're in, then underneath you put the judge's name. I do it to the right. I put the case number. To the left, I put the plaintiff and the plaintiff's name, and then versus the defendant and the defendant's name. And then, you could either center it or you could put it to the right. And you put down, this is the title of whatever it is. And then you structure the body. When you structure the body, people, understand it's real beneficial to keep that body very small. Cite the local rules that give you the right to do this.
Right.
Or the civil rules or civil or criminal rules of procedure that give you the right to do this, and say, just keep it short and sweet. Put in attachments, attach the affidavit of status. Another great thing, right after that, motion, like Chris said, motion for clarification. If you're in domestic relations court, you say, are we in an equity court? Are we in Article 1, Article 3? Give the court options to choose. So that way I may follow the rules accordingly. Now, when you put in the affidavit of status.
Yeah, hold on. Let me do this, okay?
Yeah.
Because this is what I know. This is comes now, Kirkell Pendergrass, pursuant to Rule Idaho Rules of Family Law Procedure Rule 206. This is up in my headings the way it is. The case number and the motion heading is on the right. This is a notice of appearance. Okay, comes now. Blah blah blah. I am here specially, not generally. And if it's anything that's under threat of arrest, if you don't show up, okay, then I'm under threat of arrest, under duress, under threat of coercion, threat or coercion. If I don't show up, I'm going to jail. That's under threat. Okay, so here, Rule 502, pursuant to Rule 502, this is again back to what I was just saying earlier. Defenses and objections, when and how presented. This falls under that Rule 12B stuff. A respondent shall serve a response within 20 days after the service of the summons upon the party, or within such longer period as provided by statute. This is the first thing that you file in every case. Okay, notice of appearance, especially, not generally. If you're under any threat, that's written in there. Pursuant to Rule 206 is the notice of appearance, and the motion for the affirmative defenses is right here under 502. And then I go back into the actual affirmative defenses, which is right here. How defenses and objections presented. Every defense in law or fact, notice that says in law or fact, to a claim for relief.
Do you want to go get
whether a claim, counterclaim, cross-claim, or third-party claim shall be asserted in the responsive pleading thereto if one is required, except that the following defenses shall be made by motion. Now we go back to the notice of appearance, and it says 2, 4, and 5. So 2 here is lack of jurisdiction over the person. That's number 2. Number 4, insufficiency of process. Okay. Number 6, failure to state a claim upon which relief can be granted. So that whole phrase that I say, I motion for dismissal for lack of jurisdiction for failure to state a cause of action for which relief can be granted, is pursuant to Rule 502A 2, 4, and 6.
And
that's how
when you word
works.
it, and when you word it by knowing the rules and citing it that way, it's really going to make a simple, short, sweet impact on the court of, I'm not here playing games. If you proceed forward, I'm coming after you.
Yeah.
And I'm going to make sure you get prosecuted. And it's something that sets the court back. You know, it makes them take a step back. It's kind of like the bully in high school picking on you. And then one day he pushes you and you push him back. I guarantee you, if any of you have ever been picked on when you were a little kid.
It removes the playground. It removes the bully from the playground and brings it into a fair, just setting. Okay? You get, you know, again, back to due process of law, notice an opportunity to be heard. This is your due process, noticing the court and being heard. And you're claiming, I don't consent to any other jurisdiction than this. And that's why there is a lack of jurisdiction over the person, me, as a man, because the jurisdiction you're trying to apply to me implies that there's some sort of contract that binds me to this jurisdiction. And then again, I demand the contract so that I may scrutinize it in its entirety. And you force them to produce this contract. And if they don't produce the contract, case dismissed with prejudice. So they can't refile. They're done. Now, most of the time, we can beat just about any case out there just by this right here. So your traffic tickets, any of your criminal stuff, and even this crappy ass family law stuff where they try to pull this contempt of court crap on you and send you to jail for not paying child support.
Yep.
You don't have personal jurisdiction over me because you don't have any standing. And this is not the proper forum to hear this. The common law jurisdiction to hear this.
Exactly. And that's what we're arguing now.
In common law.
Right.
Yep. And that's
the fact that we even have to argue that.
And that's it. That's the argument right there.
Right. But imagine that we actually have to have that argument, which goes back to, you need to tell me we actually had to test, can you lie in court? You know, it says, it tells the judges, how far have we fallen where we have to go back to basics like
who we are as a human being?
Exactly.
Common sense?
Right. You know, reasonableness, staple Jello to the wall. You know, good luck with that. But, you know, it's, that's like I was saying a little bit ago, there's no common ground. There's no place to agree to disagree. So, you know, like, for example, one of the cases I defeated, and it was a very simple one sentence. Then it requests that the court dismiss this case with prejudice, as this prosecution will be easily defeated on appeal based on the statute cited cannot exist in law as seen in these standards of review provided. In other words, this statute's already been tested. Here's the case law. It failed. It cannot exist in law. So because it cannot exist in law, you can't charge me with it. You don't have standing.
Yeah, show me the law that I'm in depriving here. Depriving them of their rights.
Yeah, I mean, so, you know, and so we said, okay, that's all things being equal. Yeah, prosecutor made a, you know, is long on claim. That's one thing prosecutors are good at. They're long on claim. Where they fall short is facts and evidence. So they get people so pissed off by these long, drawn out. Huh?
I said where the prosecutor falls short is they're making complaints or charges.
Right.
Those aren't claims.
Well, and that's just it. But because it's prosecutorial discretion, right, which is something that only they have, the more they throw at you, basically, that's factually deficient, the worse it is, which is one of the things we're already proving in federal court now.
Right.
So
that's where they get kicked in the mouth in the federal court. Because the federal court is Article 3 court.
Right.
And you're literally putting on some serious shit kickers, steel toe composites, whatever you want to call them, and you're saying, "Hello, meet my Wolverine, Hulk smash," and boom. And it's literally, you punch them in their mouth with this process. And when you're in court, for you novices out there, when you're in court and they ask you, well, why don't you clarify this? Keep it real simple. I put it in writing. I don't need to clarify anything.
Yep.
Well, and even over and above that, it's a real simple argument. If all you have to do is show that on appeal, the case would be overturned. The judge knows what that means. Mm-hmm. Judges don't want to be overturned. So if you can show definitively where they would be overturned and there'd be a loss, right? Mm-hmm. That loss would be generated by the prosecutor, not by you.
Right.
And because the loss would be generated by the prosecutor, we basically said, hey, guess what? There is a law for that. It's called counsel's liability for excessive costs or vexatious litigation, 28 U.S.C. subsection 1927, and applied it. And the court went,
yeah, if you're in a high conflict divorce, believe me, you want this. I'm speaking because I'm in one. You want this document in there. You want these challenges in there. And, on toppling on top of it, which, Kirk, I really hope you post it for the layman, because I believe this is something that they'll be able to understand for the novice, posted to your page, how to apply the unclean hands doctrine. So if you got an ex that, like in my case, I caught my ex cheating, hey, all of a sudden, I'm this horrible monster because she was cheating. Well, I'm hitting that with the unclean hands doctrine as a defense. Like, hey, your entire prosecution is built on lies, and it's built on you screwing up the contract, not me.
Right.
And, this is...
Let me just kind of touch on that, and I give you a perfect example. If you're in a situation, okay, we'll just go with somebody trespassing on your property, and you shoot them. Now, who has the right to a cause of action here? The man that trespassed and got shot? No, because his hands are dirty, because he is the one that trespassed upon your property. He caused a right to a cause of action. Your right to a cause of action was to defend your property, your life, your liberty, and your property, your pursuit of happiness. And any man who disrupts that and tries to deprive you of that, you have the right to defend it with arms. Okay? So this is, I know that there's especially some of my Second Amendment people that are like, well, people get thrown in jail because we don't really have what we're calling out here in Idaho as a castle doctrine, which means you have the right to protect your castle kind of thing. But there's several states that are trying to do this statutorily, and it's like, wait a minute. We have to understand the concept of law. And no man has the right to trespass upon your property and deprive you of any right. And if they do, that creates the right to a cause of action for you in defense. Okay? So
yeah, and that's something I was
contemplating. Man who picks himself up, he gets into an ambulance. They take him to the hospital. Now he wants to try and sue you. Okay? The application of the clean hands doctrine. Did this man trespass upon my property or not? Well, yeah. How did he get shot? Well, because he trespassed upon my property. Well, he doesn't have a right to a cause of action against me for defending my life, my liberty, and my property, because he was in the wrong. Therefore, motion for dismissal for lack of jurisdiction for failure to state a cause of action for which he can be granted relief, because the court can't grant him relief if he's got dirty hands. He caused the situation.
Right.
He doesn't have a right to a cause of action, which leads to no jurisdiction.
Right. And this was established in 1914. I just did the research on it while you were talking, Kirk. And the simple definition is the principle that a party cannot seek equitable relief or assert an equitable defense if that party has violated an equitable principle such as good faith. So in other words,
there's that good faith again.
Somebody trespasses onto your property, that's a trespass of property. If they cross into the curtilage, which is about 20 feet away from the 20-foot line off of your stoop or your outer wall, whatever, If they cross into your curtilage, you can declare that uninvited. You can declare that person a threat. Doesn't matter who it is.
Right.
So in Florida, we have something called stand your ground. Somebody travels into my curtilage, and I say, identify yourself. Who are you, and why are you here? And they don't answer, and I pull my gun out and I shoot them.
Mm-hmm.
Guess what happens to me? Nothing.
Yeah.
And that's why
Nothing.
that's why people don't understand why that one dude, Chris, you know the names better than I do, why he got away.
Oh, you're talking about the Zimmerman Trayvon Martin thing.
Yep.
One of the major problems with that case is Zimmerman was not in his home and was not within his curtilage. But
yep.
the attorneys argued that he had a lawful right, or he was there doing a lawful job as the neighborhood watch person. And whether you understand the circumstances of the case or whatever is irrelevant. But based on what had actually transpired, from what the jury was actually informed, they said no, there was, the state was deficient in being able to prove that there was any intent on Zimmerman's behalf to, to actually kill the kid. He didn't wake up in the morning and decide, I'm going to go kill this kid. Right. And that's what the defense attorneys argued, and the jury agreed. So that's the reason that he won.
So just to help clarify this, property, Black's Law Dictionary, 6th edition, page 1216, that is peculiar or proper to any person, that which belongs exclusively to one. In the strict legal sense, strict legal sense, an aggregate of rights which are guaranteed and protected by the government. Well, what does the Declaration of Independence say? Creator endowed rights. We are endowed by our Creator with certain unalienable or unalienable rights. Amongst these are life, liberty, and the pursuit of happiness. And those rights come from the law of nature. And if we read rights and the law of nature, we have the right to self-preservation. That's where the right comes from, self-preservation. We have the right to defend our body, our life, our property, our liberty with arms.
And your children.
One of the most heavily protected liberty interests is the right to parent.
Thank you. Took the words right out of my mouth.
So, when you apply these, maxims of law, and you apply these little motions and filings, people, for all you novice people out there, people who are just overwhelmed by this whole legal thing, understand something. The law is pure. The law is good. The law is not made without remedy or relief provided within the law. But it's so well hidden because of all the bad actors trying to disguise it to be something else. Just stand your ground.
It's hidden within the overburdensome process, right?
Yeah.
And that's one of the things that we've argued. And we're winning that argument, just so you know. And,
that legal maxim, the maximum law that we read the other night, Chris, like I said, we on the phone, what are you doing? Well, we're sitting here reading some maxims. And whatever you do in defense of yourself is to be legal. It's legal to defend yourself. Whatever you do in defense, as long as...
that's where a lot of people, when you write something, people, and if you're not sure how to, narrate properly to the court, and you write something and it's written very well. Because I know a lot of people like that. They write some awesome stuff. They just don't know how to word it. And you know what? They're just going to sit there, grit their teeth, get frustrated, and they let them. And you just remain calm.
Yep.
And
here's why
that's
so
getting
important.
Uncomfortable and starting acting out emotionally and stuff. You're doing something right.
I'm glad you brought that up, but guys, talk about timing. There's actually a maxim of law about that. Outward acts indicate the thoughts hidden within. So, in other words, if you're acting out in court, okay, that's indicative of what your intent is. So, if you get up and start yelling and screaming and swearing, don't be surprised if the court treats you like you yell and scream and swear, you know, everywhere you are and everything you do. Right. In other words, this person who's standing there making this claim against you just got really believable, and which just torpedoes your case. So when it comes to allowing these people to get you all pissed, don't fall for it.
Yeah, just try to remember. I know about the corruption. I know all about that stuff, but we still have to respect the man that's in front of you, whether it's the police officer or the judge. You know, give them the respect they deserve as a human being, as you would want to be treated, even though you know that they're acting unlawfully. Okay, you know that. Don't give them a reason to shoot you or drag you out of the car. You know, you can make your statement there in the beginning. Well, by what authority? You know, can you articulate what crime do you suspect me of committing? Well, am I free to go, or are you placing me under arrest? Well, no, I'm detaining you. Well, detain and arrest are synonymous. So, am I free to go, or are you placing me under arrest? And if you're placing me under arrest, yeah, okay, what crime are you claiming that I have committed? Claim. What are you accusing me of? Well, you were speeding. Well, that's not an arrestable offense. So, you know, you can do what you want. If you still want to continue with this, but I'm invoking all of my rights and I'm waiving none. And if you want to violate or trespass upon my rights, well, and deprive me of my rights, we're going to go to federal court. And I'm going to sue you in your individual capacity, not your official capacity, because your insurance isn't going to cover that, because your insurance doesn't cover you acting under color of law. So don't try to go after their bonds when they're acting outside of the law.
Right.
That's the thing. People, I'm going to go after their bonds. It's going to get you in trouble. Only when they're
all kinds of trouble. Right. Kind of like I'm having with my other device, where I'm trying to watch the Facebook posts.
Yeah. I've been doing a lot of.
Those are for accidents, right? For accidents, not for them acting unlawfully. That's what that insurance is for. You know, like your insurance company for your automobile. Okay, you go ram your car into a convenience store and kill 2 people or injure 2 people. Your insurance company's not going to cover that. That's not what you're insured for. You're insured for accidents. You willfully drove that automobile into the convenience store and injured those 2 people. They're going to come after you in your individual capacity. They're not going after your insurance bond, because the insurance ain't going to cover it. So it's the same principle.
Right, which is one of the reasons why insurance companies get away with taking your money and not paying the claim, because it's all in the articulation.
Yep. Well,
so, that's the one thing where they get jacked at is acts of God.
Right.
Yeah, and
so when you're talking about,
we don't cover acts of God.
Right.
Lightning struck the tree outside. The tree fell on my house. Well,
right.
Sorry, we don't cover that. Well, what do you mean you don't cover that? What the hell do you cover? Nothing.
Right. Actually,
just give us your money.
Property laws, they do cover it. I can state that. That's actually an area of my expertise.
Well, it's funny because I've actually had this conversation with a guy who was, a guy who's a lawyer, and we were talking about, proper terminology, and he was searching for, a way to describe it. And I said, you're talking about nomenclature. And he just looked at me, and I said, nomenclature is the proper terminology. That's the technical word for defining a specific thing in its true name. So you've got say plumbing valves. Well, there's different types of plumbing valves. There's globe valves, gate valves, needle valves, et cetera, et cetera, et cetera. So when you're talking nomenclature and say, I got a valve, well, what kind of valve do you have? Well, I don't know. It's a valve. Oh my God. It's like, this is the word game they play in law. Okay. You say valve, your brain goes to globe valve, a little shut-off valve that's underneath your sink. That's a globe valve. And the insurance guy is actually talking about a gate valve, which is most commonly used in water main lines. So, it's a valve. It's the same thing, but they play these word games, nomenclature, and we cover this, but we don't cover that. Well, that is the thing that always happens. Well, that's not what we cover. Well, then what the hell am I paying you for? Well, that's not what we cover. What am I paying you for? That's not what we cover. And that's where the back and forth starts.
Right. So what the hell do you cover? What am I paying you for?
So here's what I tell everybody what I've done. I quit paying car insurance 20 years ago. I have what's called a financial responsibility bond.
Yep.
And that's on file, and those funds are in escrow in the event of an accident, because all the statute says is I have to provide financial responsibility. So I said, okay, I bought a bond. Said, here's my financial responsibility bond, and now I don't have to worry about oh shit, did I make my car insurance payment this month? I mean, something you'd think is so trivial. Well, what's car insurance? I mean, last time I paid car insurance, it was like $40 a month or something like that, and I don't even know what the hell it is now. But I'm sure it's probably pretty close to almost double that by now. But that bond is actually still making me money. I earn interest on that money. So you see what I'm saying? It's all about knowing how things work, why things work, and you can make them work for you if done correctly. And I just can't play the video thing again. Man.
Oh, there we go. Sorry about that, fellas. Got disconnected.
See how you are?
Yeah, well, it happens. So, but yeah, this is where a lot of people, I believe that this is a fundamental thing that everybody should put together in every single type of case they have. I don't care what it is. Put together your entry of appearance, attach your affidavit of status of person.
Yep.
And real important in the affidavit, and let's elaborate on this for them, Kurt. Where you, on the bottom of the affidavit of status, where you say, a fan further saith not, and then you sign your name, draw a line, print your name like you normally would, not all capital letters, like you normally would, but don't forget a black thumbprint.
That's on the affidavit of status, and have it notarized.
Yeah. And have it notarized. I went to a bank to have it, and they actually swore me in. Make sure they swear you in. And they swear me in. They let me use their black ink pad. Here's my fingerprint. Use my thumbprint. And that is an identification. I've made like 9 copies since I've got this document and sent it off. And nice. I'll tell you what, whenever I get stopped, I'm just handing it off. Here you go. Here's an original copy for you, brother. This is who I am. Have a nice day.
Yeah. Yep. And it's just your personal identification. This is how you identify, and this is the only jurisdiction that I consent to. I'm not saying that you can't sue me. So if I deprive you of a right and trespass upon your property, I'm not saying that you don't have a remedy under the law. You just have to bring it under the right jurisdiction. And I'm not going to tell you what jurisdiction that is. I'm going to tell you what jurisdiction that I consent to. And if you want to bring it over to that jurisdiction, all fine and dandy. We'll go to court and we'll argue that. But as for right now, this is not the right jurisdiction. I'm not going to play by these rules because I don't consent to these rules.
Right.
If you want to continue to sue, we're going to federal court, where I know damn well I have the jurisdiction to bring the claim against you and turn the tables. If you're on the
which goes into
you turn the tables
and break down.
You're
break
done.
down that jurisdiction into all 7 of its elements. Like we were talking about. You say, well, okay, well, you have locational jurisdiction because of where we're located. Okay, because we are residents and we reside in this location. So that one I'll give you. Mm-hmm. But what you don't have is personal jurisdiction, or this is an improper forum based on the claim that's been made against me due to the fact that the claim that was made against me was criminal in nature, which under both the law and the statute demand Article 3 proceedings, not equity proceedings. So in other words, in this forum, you cannot bring this charge against me. Period. End of discussion. Move to dismiss. Yes? Right. Yes, we're out of here. Bye.
But again,
you're gone.
All of that falls under personal jurisdiction.
Mm-hmm.
Because if you don't have standing, you don't have a right to a cause of action.
Right. You're literally pulling their feet out from under them.
If I haven't deprived you of a right, you don't have standing to have a cause of action.
Correct.
They all kind of tie together in succession, but it all falls under one word. It's called jurisdiction. Jurisdiction isn't just the land where this alleged crime happened. Jurisdiction isn't
people get that confused. They think jurisdiction and they think the courthouse.
Okay.
Right? Mm-hmm. Yeah. Jurisdiction is not the courthouse. The courthouse is the courthouse.
Right.
Jurisdiction is the rules that we're practicing when we're standing in front of the judge. Right? So you can have courtroom B on floor 3. Huh?
And the law you're trying to apply.
Exactly. So just because you're in courtroom B on floor 3, which is typically an equity proceeding, all you have to do is say, Judge, due to these charges and the statutes, counsel is wishing to apply a move to Article 3 proceeding. And if the judge says no, guess what you can do? I'm hereby providing an oral notice of appeal. That's simple. And you're done right then and there.
Mm-hmm.
So,
don't let them.
Not walk out. You just, say, I will, I'm providing an oral notice of appeal. The written will be on your desk by close of business.
Or you could just say, this court and you yourself have zero jurisdiction here. Bye.
Correct.
If you try to use any kind of force or violence against me, then you're going to create a right to a cause of action for me to go to federal court for deprivation of rights while acting under color of law, Title 18, Section 242. And if that involves kidnapping, I get to seek the death penalty.
Or even on a simpler, or even to break it down to even something more simple, if they're attempting to bully you into saying, you need to agree to this under Federal Rule 8C, that's a duress situation. They can't place you under duress. They cannot force you to agree to something under duress. That's Miranda.
Mm-hmm.
1966. We've already had this conversation. The Supreme Court said no. So,
And if you're forced to sign anything under duress, people, sign it and then put the letter UD next to it.
Yep.
Yeah.
And actually add, I'm going to type it in here. UD 1-308. That is under duress, and I'm still retaining all of my rights. All rights retained.
Correct.
Say that again, Kurt.
UD is under duress 1-308. That means all rights retained. I waive none, and I retain all of my rights. And I'm
right. And the signature is not actually a signature because it's under duress.
Right. It's not enforceable in any court.
Correct.
You signed that under duress. I was threatened, coerced.
Yeah.
Somebody said I'd go to jail if I didn't. Somebody said they were going
Right.
to kidnap me if I didn't.
Right.
Whatever
Somebody
they
said they would take my kid.
I'm going to haul your ass off to jail. Okay. UD 1-308. I just signed it. There you go. See what you can do with that. I'll see you.
And you'd be surprised how many quote unquote officials don't even have a clue of what that means.
No.
So, you know, it's by the time it hits the judge's desk and they look at that and they go, who in the hell did this?
Right?
This is not a
Who's
training
bringing
issue.
this
This is
crap?
somebody's getting their butt chewed in judge's chambers issue. That's what that means.
Yep.
So,
Yeah, as soon as you, if you do go to court and you have that type of signature on there, following your signature UD 1-308, the judge is gonna do the Homer Simpson. Don't. Who brought this in front of me?
right?
Because you have no standing now. Whoever brought that has no standing.
And here's the bad part, and this is the thing that pisses the judge off. They can't even force you to pay costs and fees because you're there against your will and it's on paper. So they cannot apply the law.
It's not
So
under
define
protest.
against your will.
John
sorry?
Patton and Rebecca, it is not under protest. It is under duress.
Correct. Protest
Okay,
is different than under duress.
Yes.
Okay, so define what you were just saying, because I've been kind of in and out doing other things.
Oh, yeah,
So-
party to the party.
Glad you can make
Always
it.
late to the party, but I'm always
Right.
stylish when I come in late.
Well,
Okay.
see, this is the nice part I like about law.cornell.edu. It has the UCC. I'm just gonna post it. UCC Article 1-308. It was formerly 201. Performance or acceptance under reservation of rights.
Okay, here's duress as defined. It was from the 13th century. Strictly, the physical confinement of a person or the detention of a contracting party's property. In the field of torts, duress is considered a species of fraud in which compulsion takes the place of deceit in causing injury.
Yep.
So in other words,
act of fraud.
That's a fraud, and it's also a cause of action.
Yes, it is.
Which is why it appears in Federal Rule 8C, which
Right.
is causes of action.
Yep.
So,
Bingo.
or affirmative defense.
Yep.
Right? So
it's affirmative defense and a right to a cause of action. It's a
correct.
counterclaim.
Both. Correct. And depending on context, it's both.
Yeah, that's what I'm saying. It's both. It's an affirmative defense and a counterclaim. It's a defense
Correct.
against their claim to a cause of action, and it's
Correct.
a counterclaim for a right to a cause of action against them. So again, this
Someone could you use it?
anytime that you can find fraud, it's time to turn the tables. They acted in fraud. Here it is. And I'm claiming deprivation of rights. What do you
Right.
say, Judge? Or Mr. Prosecutor?
So for example, in equity court, we'll just say family court because that's the topic tonight. You have a duress situation where, you know, lawyers from Dewey, Cheatham, and Howe are forcing you to sign this document, and you know it violates your rights. So you sign it as Kirk has indicated, your name, UD-1-308, and it's an unenforceable signature. It's an unenforceable document. Toilet paper is worth more than that document. So
How is that under signing under duress? How is that? How is that?
it voids the document. It voids the signature.
Ah.
Remember Schumacher versus Schumacher.
Right.
And for a condition of fraud or unjust enrichment, the action is not so much voidable as it is void. Right.
Right. Oh,
Okay.
no wonder why you were pissed off
Same
that I put
principle.
that on there.
You what?
I said, no wonder why they were pissed off that I wrote that in there.
That's why I let you go. I figured you knew what you were doing.
Right? Two things that I didn't even know I'm doing.
Under protest. He keeps saying, John's like, oh, it says under protest. I just posted it. It does not say under
duress.
What you have to look at is the affirmative defenses under.
Well, let's help him out. Let's define what under protest is, because maybe it'll help him wrap his head around it a little bit better.
Well, I've already put protest out there, and protest, under protest, is claiming something that is about to happen or something that has happened is a moral wrong, and it is a written declaration. That's what a protest is. Okay. Well, we're actually talking about under duress is being threatened or coerced, and that's actually under that Federal Rule 8C, under duress.
Right.
I'll pull that up and show that one too.
Correct.
Okay, well, UCC 1-308 is actually performance or acceptance under reservation.
Yes,
reservation
not UCC. Not UCC.
Assents to
UD. Uncle David.
Oh, Uncle David. Oh, sorry. I'm on the wrong one. Sorry. I'll just go back to mute again. Just put me there and I'll be happy the rest of the night.
That's all right.
We love you. We love you, Crystal. That's all right.
You know, we just need to get it down correctly so that we all know.
Right.
Okay, so what's the difference between that one and UCC-1-308? What's the difference between the two?
The difference between what?
UCC 1-308, which is signing under duress, and what UD is.
No.
Okay.
Okay.
Yeah, John.
I guess I need.
That's no problem. We can clear that up.
Okay. So, if you are being forced to sign something, okay, force. There's a use of force, a threat of force. If you don't sign this, I'm going to haul your ass off to jail. That is under duress. You are being forced to sign it. That is where UD comes in. Now, the UCC 1-308, you can, when you're not under duress, when you're not technically being forced to sign something, but most of the time, you are being forced to sign something. Like, okay, how about going getting a cell phone? You sign that contract, you could put UCC 1-308. Nobody's forcing you to sign that. You're not under threat of arrest or being kidnapped, taken it if you don't sign this contract. But this is a contract, and you can reserve all of your rights by just putting UCC 1-308 behind it. But when it's under duress and under threat of arrest or some sort of use of force and violence against you, that's under duress to sign it.
So okay, what's the code again?
UCC, Uniform Commercial Code 1-308. That's Article 1, Section 308.
Okay, I know. What's the UD one?
UD is under duress.
Okay.
They're similar, but they are different.
Right here. Article.
We cannot see you right there, Kirk. You know, you're right there as my over here.
Oh, okay. So Federal Rules of Civil Procedure, Rule number 8, General Rules of Pleading. A, claim for relief. B, defenses, admissions, and denials. Okay. C, affirmative defenses. And these are bullet points. In general, in responding to a pleading, a party must affirmatively state any avoidance or affirmative defense, including, and number 5 is duress. So you're under duress when there is a threat or coercion, like, okay, I want you to sign this plea bargain. If you don't sign this plea bargain, we're going to go to trial, and I'm going to make sure that you lose, and you're going to go to prison for the maximum time. That is under duress. You're being threatened with going to prison for the maximum time if you don't sign this plea bargain.
Which is what prosecutors do with defense attorneys all the time, where they make these quote unquote deals.
Yes.
Where the attorneys both make out and you get the shaft.
Because it's a win-win. Okay, same thing.
Well, win-win for them.
CPS will tell you, you need to sign all this paperwork, and then we're going to drop the plan to get your children back to you. No. First of all, I'm not going to sign that. Well, we're not going to get you your kids back. Okay, fine. UD 1-308. So if CPS tries to say, well, here's the document they signed, and the judge looks at it and say, yeah, take a look at my signature there, Judge. Don't. You're right. This is void. Sorry. Well, why did you sign it like that? Well, because she told me that she was going to keep my kids if I didn't sign it. Oh, so you were threatening to kidnap these people's children if they didn't sign this paperwork, Mr. or Mrs. CPS worker? Well, we acted in good faith, Your Honor. It's our policy. Well, your policy sucks. It's unlawful. That's why I signed it under duress. All right, folks. So that we're at 3-hour mark. I know that lots of good information. Great conversation tonight.
I'm at 2:33.
Our sponsor.
Well, I love you guys.
I love you guys too. I do. You guys are awesome people. So the sponsor for Blog Talk Radio is Brian Kinter, Neil Shelton, Cheyenne Davis, and Randy Davis. They both have shows on our Future of Our Children network on the Blog Talk Radio. And American Common Law Academy out here in Nampa, Idaho. We have Lee Arthur Rice, Tony Pellegrino, Fred Kelly Grant, Angela Peru. She works for Bronco Bail Bonds. So kind of a neat little setup there. And then Chris Hallett, I've basically invited him on. I wanted to do this last show to invite him on as my co-host for Dummies. How do you like that, Chris?
I think we just blew up the court.
We need to get this education out there. And you know, I know the stuff that you're working on with Crystal, we can't really discuss much of that, but in due time, the hammer's going to get dropped, and when it does, that's case precedence.
Yep.
Here we come.
Yeah, and it's going to be a big Moab over the state of Utah and Idaho.
I want to thank Robert for coming on. He's a truck driver, so he's kind of busy. I may do another show. I'm going to start. Ted and I kind of touched on this, and I've touched base with Robert about it because he's a very knowledgeable guy as well. So maybe doing another show might be not quite as long as this, and it might be a little bit different than we do here. So, but thanks to Christopher Hallett and Crystal Ante for coming on tonight. I do appreciate your knowledge, your brains, and us working together and being kind and courteous to one another. And I want to thank everyone who tuned in tonight and watched this. I tried to watch the feed a little bit. Got 2 laptops and my phone all going at the same time here. So, yes, thank you for tuning in. Any other comments from you guys?
Thank you for having me, guys. I look forward to doing this much more often. I think we could we could turn this into court talk, which was, if anybody listened to talk radio before, remember car talk, we could do court talk. You know, so.
Right.
Turn this on. Yes. Beautiful.
And thank you, Ted, for being our producer and putting all the audio video stuff together for us and making this all happen, because, you know, that's a unappreciated job or whatever term you want to use there.
No, it's cool, man. We met when I was promoting a certain event, and now the Marches Live, I'm hoping, you know, is promoting other people's voices. I want to bring people together, and your voice is very educated and very strong, It's not hateful or spiteful towards anybody. It might be pointed at times, but it's because you know what you're doing. And when Chris and other people recognize that and respect that, that's how people get on the same page. Is discussing things respectfully, in a pointed way.
Yes.
If you can't handle that as an adult, then, and unfortunately, people who are victims aren't necessarily the best advocates. But you guys are solid. You and Chris and Crystal, and maybe Ante as well. You're a solid team. I love it, man. I love it. And I couldn't be happier being a part of it and helping in this way.
Well, we appreciate you too, Ted. Yeah, your work is instrumental in us getting this information out to people. Because, you know, for us to do the work and not be able to disseminate it is, you know, dissemination of the information is just as if not as important as doing the research itself. So.
Right. Well, I mean, I couldn't be happier with you working with Kirk, Chris. We've been talking for at least a year now, and not all the time, obviously, but once in a while, just to bring me out of the doldrums of misery, thinking that knowing that people actually understand this stuff and are working towards an end is just so amazing to me, and you guys working together is just that much better.
Well, I look forward to being able to explain the process and how the practice works. So when people walk into court, you won't be scared because you got nothing to be scared of.
Right.
So we're going to show you why as we go on. So that said, thank you guys. Love you all, and we're going to make this happen, whether they like it or not. So it is what it is.
Hey, we're doing our due diligence under what executive order is that?
13781. Thank you, Mr. President. Love it.
What does that say?
That is the one where President Trump issued an executive order asking for help from the citizenry to help him redefine the executive branch. So I put together a practice called E-Clause to help work with the federal courts to define the term emoluments and what it means in context of government. So I figure I can't make my report to the president until we have the definition of the term as it's recognized in the court. And so far the court agrees with that assessment. We have to test it. So, because it's never been tested, we're doing something nobody's ever done before.
Scary but true.
Yes, it is. So imagine that. The Constitution is ratified in 1776 and there are parts of it never practiced. Wait, what?
The president's just one man. He can't do it all.
That's right. He needs our help, everybody.
It's the people.
Do what you're good at. Do what you love. Make it work for you.
Being blonde. Okay, kudos to you guys. And love you guys, and peace out, and we'll talk again very shortly.
Absolutely.
Okay, peace out. Love you guys.
Love you guys. Love you too, Crystal.
Okay, see you guys. Okay, bye-bye.
Thank you all. Have a good night. God bless.